May I please, my lord?
Yes,
My lord, I beg to mention item number 5, my lord,
5. Yes, supplementary hearing.
with consent from the other side, my lord. Matter may be taken up to 2 weeks, my lord. Yes.
Mr. So-and-so makes mention on behalf of Mr. You're appearing for, or is your name here in the cause list?
Yes, my lord. I'm
Yes.
M. Doji, my lord.
Okay, Mr. M. Donji, learned counsel for the appellant, who prays for adjournment of the matter and submits that he has taken the consent of the respondents. In view of the above, list after 2
2
weeks.
weeks. Oblige.
Your Lordship. I beg to mention item number 4.
4. Yes.
I'm on behalf of leading counsel N. Fata.
Hmm.
He is out of station, so this matter may be kindly taken up to 3 weeks.
Mention is made on behalf of Mr. N. Panda, learned counsel for the petitioner for adjournment of the matter since the learned counsel is out of station. In view of the above, list after 2 weeks. Yes, 2 weeks.
May I please, Your Lordship? Well, this matter relates to implementation of National Food Security Acts and the Anganwadi center has to function, but then in some places, Anganwadi has no basic facilities. Whereas as per the Act, it clearly says that it should have basic minimum facilities under section 4, 5, which talks about basic water facilities, which talks about toilets, which talks about electricity connections. Because Anganwadi center is very important because this is a center where nutritional supports are given to the children 3 to 6 and 3 to 6 months and then 3 years to 6 years, and then malnourished children. Beside that, the pregnant women, lactating mothers, they also serve nutritional supports through the Anganwadi centers. Now, if I see the you'll also may see the Anganwadi center means it's a child care and development center set up under the Integrated Child Development Services of schemes of central government to render services covered under Section 4, subclause A of subsection 1 of the Section 5 and Section 6.
Where are you reading from?
This is a National Food Security Act.
Yes. Section?
It's the definition 1, Anganwadi.
Yes.
Definition of Anganwadi, my lord.
Hmm.
It's in a definition number 2, definition of Anganwadi. It's marriages again.
Yes.
Means a child care and development center set up under the Integrated Child Development Services schemes of the central government to render services covered under Section 4, clause A of subsection 1 of Section 5 and 6. So this is a very important. Now I will just take to Section 4. Section 4 is page 7. Section 4 talks about nutritional support to pregnant women and lactating mothers. Merit subject to such schemes as may be framed by the central government, every pregnant woman and lactating mother shall be entitled to a meal free of charge during pregnancy and 6 months after childbirth through the local Anganwadi center, so as to meet the nutritional standards specified in the Schedule 2. So I will just take to, I will take to the Schedule 2. Now I may just read B. Another is that maternity benefits of not less than rupees 6,000 in such installment as may be prescribed by the central government. Now I will just take to the Section 5, which talks about nutritional support to children. Clause 1, subject to the provisions contained in Clause B, every child up to age of 14 years shall have following entitlement for his nutritional needs, namely A, In case of children in the age group of 6 months to 6 years, age appropriate meal free of charge through local Anganwadi center so as to meet the nutritional standards specified in the Schedule 2. B. In case of children up to class 8 or within the age group of 6 to 14 years, whichever is applicable, one midday meal free of charge every day, except on school holiday, in all schools run by local bodies, government or government-aided schools so as to meet the nutritional standards specified in Schedule 2. No, I made to take to subclause 2. Every schools refer to in clause B of subsection 1 and Anganwadi shall have, that's important, your lordships, have facilities for cooking meals, drinking waters and sanitations.
Yes.
Yeah, this is the criteria under this clause. Now I'll just take to the Schedule 2. Schedule 2 talks about how much the food and the age groups and calories in page 31, 21.
21.
Yes, Schedule 2. Schedule 2 is talks about a nutritional standard. And if we see the nutritional standard, may I read? Nutrition standard for children in age group of 6 months to 3 years, age of 3 to 6 years, and a pregnant woman and lactating mothers required to be met by the providing take-home rations or a nutritional hot cook or meal. It's a two-way. One will be a take-home rations. Another is a nutritious food cooked meal in accordance with the integrated child development services schemes and nutrition standard for children in lower and upper primary classes under midday meal scheme as below. Now here categories are here, category and type of meal, calories and proteins. So in the serial number 1, children 6 months to 3 years, one category. And second category is children 3 to 6 years. And third is children 6 months to 6 years who are malnourished. Fourth is a lower primary school. But here my concern is 6 months to 3 years and 3 years to 6 years. And children of 6 months to 6 years who are malnourished. So and then serial number 6, pregnant woman and lactating mother take home rations. In the case of serial number 2, children 3 to 6 years who are visiting in Anganwadi centers, they have to be served morning snacks and hot cooked meal in the same Anganwadi centers. So that is the criteria under this schemes and under the Schedule 2.
Mm.
Now, as per this, there have been some fact finding done by some of the NGOs, especially in the 4 centers. That is, one is called Talo, Upper Talo, Lower Talo, and Puk area in Lower Subansiri districts. And they found the Anganwadi center was not functioning up to the mark. There was no any toilet, no toilet was properly working. No food was cooked in the Anganwadi centers. No water facility was there. No electricity connection was there. So this was the situation in the 4 centers, especially in the upper Sindh. There are many centers, but then the fact finding was done in these 4 centers. Now, in this case, they filed the counter affidavit.
Yes.
We also filed a rejoinder. And then after also they filed another additional affidavit.
Yes.
So if you go through there,
One of the points is that the building was destroyed during monsoons or storm, and the Anganwadi center has been run in some private home also, isn't it?
yes.
So what happens?
Yes, they are saying that is a partly implemented.
Yeah, in 2 places
Yes,
where it was run down by storm, isn't it?
yes.
The
I will,
additional affidavit.
additional affidavit says that I will just take to the some of the their
Let's come to the additional affidavit.
affidavit.
Yeah.
Yes, I'll just take to the additional affidavits.
So you're not happy with the reply, is it?
We have not filed a reply, in fact, and this is the additional affidavit.
So.
But then in the
you
first
are-
counter affidavit, we file a reply.
Yes, saying that it's not. So in the fact finding, they had submitted a report with photographs.
Yes.
Based on that, the state government has also replied, giving us the factual situation.
Factual situations.
Yes. So what's wrong with that? Let's come to Lower Talo.
Yes,
Anganwadi
lower
Center.
Tado, yes.
Yes.
So
What
lower,
is the explanation? Huh?
yes, lower Tado, it says that there are 13 children. And I'll just take to the important serial number.
Getting it, no? This is a reply. Additional affidavit was filed on 29th November 2022.
Additional affidavit page 3
Wait.
and lower Talo Anganwadi
29th
centers.
November 2022. There is an addition. Is it or not? Yeah, I think it's in the end. Reply to remember. This is on 29th November 2022.
There's two affidavits. One was filed in 23/11
That should
2022.
be reply to rejoinder affidavit. On 29th November, a reply to the rejoinder affidavit. This file.
Yes, this is a reply to the regional applications. Yes.
Reply to rejoinder. Yes. Yes, 29. Yes, 22 November. Additional affidavit, yes, I mean, the dates are different, but. Yes, it is 29th here, yours is 22, that's all, yes.
Yes, may I take to this one,
By the state respondent.
State respondent,
What is this?
additional affidavit.
Yes.
In the case of lower Talo Anganwadi centers,
Page 3. Oh,
as per the fact finding, it was lower Talo is empty, but then they say that central is not empty as per supervisor. They are saying that as per the supervisor report, there are all teaching materials and workers helping performing their duty. That is what they are replying.
mhm.
And in the case of there's no benches, desks and blackboard in lower Anganwadi, they say no provision for providing this benches or desks in Anganwadi centers. Maids are provided for sitting of children, blackboard available. And in the case of kitchen, it said there is no kitchen for the preparing food, but what they are saying that kitchen available as reported by CDPO. But this
So
is a
if-
report of the, this is a, yes,
So CDPO says kitchen is available.
available.
So you have to cross-check that.
Yes. But then, as per our report, there is no kitchen, my lord.
So who's the CDPO?
CDP is child
Yes,
development.
no, where's the report of the CDPO? Is it here? in-
There's no report. There's no report enclosed in this affidavit. Your
You
lordship.
see, because then you will have to,
They should have filed reports. But then they have not enclosed the reports.
I think you will have to enclose the report of the who is the CDPO who made this report? So that the petitioners can cross-check with the concerned CDPO. Simply on paper, it is there, it is not
Yes,
there,
that's true.
countering, how can we decide, isn't it? So when you file your affidavit, a reply to the counter affidavit, you have to substantiate it with some documents. So if you say that the report of the CDPO is not there, because then the petitioners will have to check with the concerned CDPO, cross-check the report, as you're saying that kitchen is there. When we went, we found that there was no kitchen, because this is all in the interest. I'm sure the
Yes.
state also wants to
Yeah,
implement.
that's it.
The state is also going to try its best to implement. So we are all working together to
Sure.
ensure that
That's to
the-
be functioning.
yes, the interest of the children,
Children.
Anganwadi children are there, because it's all for the upliftment, it's all for our, in our interest. So when you say that, one says there's no kitchen, the other says there's kitchen.
If Lordship come to page 21, Lordship. my
21.
Yes, Lordship.
Mhm.
Here, Lordship, the information has been furnished by the CDPO, Lordship. It's already
Okay.
here, Lordship.
Okay, so the report is there. Now, who is the concerned CDPO?
Dani Yami, this is in child development project official also.
Yes. Dani Yami.
Yami, she also.
So maybe,
And apart
Yes.
from that, apart from that, so far infrastructure lordship, especially is concerned
Mhm.
lordship. If lordship come to page 12 of my epidemic in the opposition lordship, there we have taken a categorical stand lordship.
destroyed.
Earlier, the main epidemic in opposition lordship,
Hmm.
there we have taken a categorical stand lordship. Initially lordship, the fund allocated for infrastructure development lordship,
Hmm.
1,25,000 only lordship. 1,25,000 only lordship. That was enhanced to 175 in year 2008 lordship. And then lordship in year 2013 lordship, it has been enhanced to 4 lakhs and 50,000 lordship.
Is This Union of India, they have filed their
Their lordship,
affidavit
on-
showing the
yes.
funds allocated.
here
Yes, my
lordship, we have taken extended lordship. So far, this enhanced amount from 175 to 450 is concerned lordship. This scheme is yet to be implemented to the state government and fund has not been released by the central government. It's our categorical stand.
No, this is the
And,
Anganwadi center of
and
not of.
on that issue, the central government was directed to file affidavit
They
lawsuit.
have filed.
They have filed lawsuit, but they have not categorically taken any state lawsuit. This enhanced amount has been released to the state government lawsuit. If lawsuit see the lawsuit, the affidavit filed by the central government lawsuit. There's nothing substantiating
Who's
or
appearing for the central government? Yes.
And our affidavit is very much clear. Malad, the funds sanctions, that will be malad is a malad the release process is
Page,
malad
page.
page number malad of my affidavit, page number 7 malad. Para 13, para 14 malad.
Number,
Malad
respondent number.
respondent number 1.
Yeah. Hmm.
Affidavit filed by the one malad
The last
One
district.
under secretary malad. Sri K. Nivasan, yes. Sri Nivas. Was
So
filed
the
on
state government is admitting that it is not as per the standard because funds were not released, isn't it? Now, the central government says that funds are released.
yes, ma'am.
So what do we do? Oh, so
Madam,
page seven, I think. page
Para
7 is-
para 13
ah,
and
para
para 14
13.
malad.
Ah,
The details of the funds, Malad, I'm reading FERA 13, details of the funds released to the state government in to the state of Arunachal Pradesh in the last 5 years under Anganwadi service scheme is under Malad. In the year 2017-18, Malad released amount has been released 18, 19, 20, 19, 20, 20, 21, 22, 21, 22. Malad, this case, this was filed in the year 2019, this PIL Malad.
hmm.
And in the last malad, the amount section and the released is 12,000 malad. It is in lakhs malad. 357.17 lakhs malad. It is released malad, as per our epidemic.
So now-
And again,
Since it's like one is it's done, is what's not done, huh?
Yeah.
Yes, yes.
And madam,
Let him complete, let him complete.
para
Let the central, huh? Yeah.
para 18 para 14 malad.
Hmm.
Again malad. This is the amount released malad. So
Upgradation.
yes malad.
Yes.
Yes, upgradation.
Para 14. In addition, the funds have also been released to the state of Arunachal Pradesh as under Malad for upgradation, Malad, for provisions for the drinking water facilities and Malad for construction of the toilet in the
Yes,
Anganwadi
yes.
centers
Mm.
and
For
maintenance.
purchase of furniture.
Last Malad, the release is 2019-20 Malad.
Hmm.
It is arrest 112.5 lakhs. Means 1,000.
Yes.
It is in lakhs, madam. So therefore, madam, we have from our side, madam, the amount has been released, madam. And para 15 is also, madam, relevant, madam. The central government has also released the funds to the state state government of Arunachal Pradesh under the person Abhiyan for nutrition and other companies. This is the statement of the funds released and the utilizations under portion Abhiyan as on 31st March 2023. Page 9, madam.
Hmm.
It is 2020, madam. So far 2020-21, madam.
Hmm.
We have released madam the 999 madam rupees, madam,
99
in
lakhs, yes.
lakhs, madam. So, madam, it is wrong to say that madam, the central government is not releasing any funds to the state government. Madam, the management, everything, madam, the supervisory, madam, other things has been done by the state government. And there is no such case that madam, no single letter, if the affidavit of the madam, the state government is produced, madam, there is no any madam, the seeking for the funds for the releasing of the madam, the amounts from the ministry, madam. Madam, if there is a deficiency even in the madam, the releasing of the funds, madam, that correspondence has to be made at least.
Hmm.
But there is no madam, the whisper about. They are only saying that no funds has been released. But from our affidavit, madam, it is very much clear that madam, letter issued by the ministry is also madam, on the last occasion, madam, I placed madam, the amounts released, madam. Same has been come in the form of affidavit, madam. So therefore, madam, from the central government side, madam, everything is done.
Yes, so the state government, if you look
Yes,
at
ma'am.
page eight, just look at page 8 of the affidavit filed by the Union of India.
Loss.
Here,
Page 8.
page 8, paragraph 14. Here, the funds have been broken up. One is for construction of Anganwadis, toilets in Anganwadis. Okay. Then the second one is for the maintenance of the Anganwadis. Then the last is purchase of equipment and furniture. Here, when the funds have been given for purchase of equipment and furniture, and you're saying that no fund has been released and mats are provided, I think you'll have to
No, no.
explain that. What is the meaning?
My
of this?
stain in the lawsuit, the affidavit is the
Hmm.
lawsuit, not at that enhanced rate lawsuit. Because earlier it was lawsuit 125, then 175, then 450 lawsuit. At enhanced rate of 450 lawsuit, the amount was not released. That's our stain lawsuit. So for 170, it's being released, not disputed lawsuit. Otherwise, lawsuit, I may be allowed to take instruction from the department, because why I'm submitting is lawsuit from this affidavit. It's not discernible lawsuit. At what rate it has been released lawsuit.
So maybe you reply to this affidavit explaining.
Then I need to take instruction
Yes,
from the
yes,
department.
you have to take instructions, find out how.
But
the
I'm
funds-
simply pointing out lawsuit from
Yes.
the statement government made in the
Yes.
affidavit. It's not discernible at what rate it has been released lawsuit.
At what rate?
Lawsuit, because at enhanced rate or lawsuit, the earlier all rate lawsuit. The amount has been released, just not disputed lawsuit, because it's being run at the lawsuit.
Have you raised that issue before the union government?
Lawsuit,
Any questions, sir?
that part.
Because larger public interest is involved.
Lawsuit.
What have you done with the funds that you have received?
Lawsuit, that part I have to check that, because this scheme is centrally sponsored scheme, and central government knows lawsuit. It's being run as
But
their
it has to be implemented by you.
lawsuit. That's
So
correct.
then you'll have to explain how the funds that are released
L-
have been used.
Hmm.
Okay,
Lawsuit.
and if additional amount or second something is required, not enough funds, then you'll have to justify or the amount required and why the scheme could not be implemented due to the lack of funds.
Lawsuit.
Something has to be there.
Lawsuit, but then I may be allowed to come with
Okay,
instruction
yes.
lawsuit.
Yes.
Your lordship may also see para 11, which talks about notice.
Para 11 of what?
Para 11 of the
Yes,
central government, which also talks about how much the components under Anganwadi services. This is a page 6, which also talks about the fund which is allocated general salary and S&P. It's a 90:10 ratio, 90:10. Almost a fund is from the central government.
State government has also been releasing the 10th.
Yes.
The
Central government will-
state share has been released also. 10% out of the 90 received, state has to
Yes, that's
release.
at a ratio of 90-10 loss.
It's been done by the
Yes.
state, no pending amount, okay. Then with so much money that has been released, sanctioned, I think the condition of the Anganwadis, which is seen in the pictures,
Yes,
some explanation or has to be given, isn't it?
this is really pathetic condition, especially not only in this place, in others, Anganwadi centers also, other PL also in the same situation.
So we're dealing with Lower Talo Anganwadi and then
Lower Talo,
Puk Anganwadi Center to, how many centers? Upper Talo,
Puk Anganwadi,
Puk Anganwadi, then Upper Talo.
Upper Talo, yes.
So we are targeting year.
4.
Which is the fourth one?
Three
Three
centers, yes, madam.
centers.
Yes, yes.
So the PIL is concerning these 3 centers
Yeah,
only.
3 centers
is it?
only this one.
How many centers are there altogether otherwise?
Yes, yeah. May I just take to the affidavit of the central governments, which has a clear figures on that center. madam.
So the other centers are okay? Are they up to mark?
They are also not
Your
up to the
PIL
mark.
is not concerning
They
the
are
other
not.
centers.
They
So
are-
presume that the other centers are okay.
Let's hope
So
that
now
that
these
is,
3 centers.
Yes.
Ah.
I'll just take to the page para 10, which talks about total sanctioned Anganwadi projects and Anganwadi centers in para 6, page 6, para 10 of the central government affidavit.
Hmm.
The merit,
Hmm.
in the state of Arunachal Pradesh, the details of Anganwadi projects and Anganwadi centers are as under 31/12/2021. Sanction is 98, operational 98, and Anganwadi centers, it is 6,225. This is only, out of that, only 3 centers.
So only 3 centers are, it appears.
It
the
appears.
PIL,
Yes.
3 centers are not up to the mark. Is it?
In fact, the fact finding was only in the 6 centers, my lord, your lordships. So that's how we are also getting the picture that this will be the same picture in all over Arunachal,
No,
But we have
now
only the-
that's a presumption.
That's a presumption, but then
That, so anyways, these 3 Anganwadis that have been pointed out, I think explanation, more detailed explanation has to be given since the center says that we have issued so much. So how is this split up? The state has to do a comprehensive homework and find out. Isn't it?
No, sir, we have filed a detailed affidavit, also, replying regarding
Reply.
the status of all these centers, also.
Yes.
Only regarding this amount, also, which the central government has stated, also, on that aspect only. Otherwise, also, I'm ready for rest.
3 only, 3 only. Yes, yes. In the next stage, no? So for these 3 Anganwadis, find out the funds, how it was utilized for these 3 Anganwadis.
For this, so per the amount released by the.
Yes,
Okay. That
Okay.
part, right.
because now one point that is very glaring is you said that no provision has been made for furniture, mats are provided. But as per the breakup of the funds that is released by the center, and there is a breakup for purchase of equipment and furniture also.
And
That
allegation,
doesn't tally.
an allegation is not that laws, the fund released by the central government is being not utilized in these 2 centers, 3 or centers laws. Or centers.
It's not up to the mark.
That's not disputed laws.
Hmm.
But the question is lawsuit, whether this amount, because our stand is lawsuit, since the amount has not been released at the enhanced rate lawsuit, therefore lawsuit, the standard
Enhanced
facility
rate
could
of
not
how
be
much?
provided.
What?
Lawsuit.
What is the enhanced rate? Where's here this thing?
450 lawsuit, 4,50,000 laws.
Where in your
Page
affidavit?
13 lawsuit, page 13 of my affidavit.
Our concern is, yes, fund is no doubt is there, but then our concern is that it should be functioning, that's all, my lord. Should have been functioning as for the fund allocations.
Their explanation is that the required funds, enhanced requirement of funds has not been released. Okay, now the central government says that we have released,
You release them.
this is the funds that are released. So you explain whether within the affidavit that has been filed by the Union of India, your enhanced rate is also included? Or if it is not included, where is an application? Where is your prayer for release of the enhanced rate? Which I don't think is there in the affidavit.
Yeah.
But
On
the
the- on that-
Anganwadi center is not a new one, it is an old one, your lordships. So I think the,
But let them explain, isn't it? And then we'll have to get the assurance that if it has not been released as per your prayer for the enhanced rate, which we have to show also in the affidavit, that we have prayed for so much, a letter, a correspondence letter should also be there. Have you enclosed that? No.
Yeah, that is.
So you
I'll
enclose the
come with that
correspondence.
instruction. I'll come with that.
Yes. I heard Mr.
ESMO.
S. Mo, Learned Counsel for the petitioner, along with Mr.
Yes, Kapil.
S. Kabil,
2,
Learned
4 and 5.
Government Advocate. Is it
Close,
additional?
close.
A government advocate for the state respondents and Mr. P. Tabu. Is it? No. Kato.
M. Kato.
M. Kato. Learned
VAGA.
VAGA for the Union of India. It is seen that the Union of India has filed their affidavit, counter affidavit explaining how the funds were released by the central government. However, the learned government advocate submits that the said affidavit filed by the Union of India does not show the enhanced amount which was paid for by the state government for the full and effective implementation of the scheme of the schemes under the National Food Security Act, 2022. The learned government advocate raised that he may be given time. No, for that, we can say that we have noticed that even though the state government submits that an enhanced amount of rupees for how many lakhs?
And there's
Amount of rupees?
450 lakhs. 4 lakhs
450.
50,000.
4 lakhs 50,000.
50,000 for Anganwadi center.
Okay, has
For
been
infrastructure.
applied for the infrastructure of the Anganwadi centers. However, there is no document to support such claim. It therefore cannot be discerned whether the said amount said to have been asked for is included in the affidavit filed by the Union of India. In view of the above, the learned government advocate is to get instructions and also file the required documents. Substantiating his claim that additional enhanced amount has been applied for and not received till date. List after 2 weeks. Anything else you want to add?
I think, next PL is in 4 centers, madam. There's 2 PL.
Okay, so the next is concern.
Next
other four
concern with,
centers.
yes, next concern with 4 in Anganwadi centers. The same order can be passed.
Same order, isn't it? For the other 4 also the same amount? Okay, so for all the 7, 4 plus 3, you have paid for 4 point something. A total, is it?
Lordship is not about this centers only, Lordship. It's about the Lordship scheme, Lordship. Under the scheme,
Okay, for
Lordship.
the scheme, the whole scheme.
Lordship.
How
Under
much have you
the under
paid
the
for?
enhanced scheme,
Enhanced
Lordship.
is how much?
4 lakhs 50,000, Lordship.
Only?
Per lakhs
Uh-huh.
per
Per-
Anganwadi center. As per the
Okay.
enhanced scheme, Lordship.
Okay, so I think we have to mention that.
Lordship.
4 point something lakhs per center as per the enhanced scheme. Okay, we incorporate that something. Yes.
Problem. Problem.
Alright.
My lord, this will be the 3rd occasion, neither the petitioner nor the amicus is present for lordship, my lord. If your lordship see, my lord, last order, my lord, 14 and 20, my lord, 14 to. The petitioner is there, I'm sorry, my lord.
Oh, the petitioner is
Yes,
present.
in person is present.
In person, you don't have a counsel to represent you?
Amicus
Yes,
was appointed,
this court has had
Who's the
appointed
Amicus,
Mr. Dui Laji, my lord. Mr. Laji
Mr. Laji, he is not present today.
is not present today.
they are not interested to pursue this
So
case.
are you praying for someone else? We can appoint someone else.
My lord, kindly advise, appoint senior lawyer who have
Do you have
credibility.
someone of your
And
choice?
otherwise, you take, this court should take this case as a suo moto. I have already filed 3 PL last year, to and fro. It's
Do you
very
have
difficult for
someone
me.
in mind?
Yeah.
Do you have a senior advocate on mind who can be appointed?
I think better, you know, who is the a good lawyer in the court.
I think there is a list in the registry that
Yes.
maintained, my lord.
Whom should we appoint? This is concerning that sentence. What's the PIL about? What is the PIL about? Oh. Who is present today? Is Mr. Deepangin available today? Someone who's here.
I have seen him a couple of minutes before.
Yes, he was there. Or Mr. Tony Patil is here, my lord.
Yes, who's there? Yes, please. M. Patil,
No, T Patil.
T. Patil.
Tony
Okay,
Patil.
okay, where's he?
Mr. Panging is there.
Pangin is also there.
Huh.
Kindly appoint him.
Mr. Pangit, can you be an amicus curiae and assist the court
Yes.
by representing the petitioner in this PIA? Yes, so
Before
And
your
then maybe
lordship
also-
passes any order, my lord. Basically, in this PL, what exactly they're asking for, my lord. My lord, under PML Act 2002, under section 40 and 49, that matter should be investigated by the ED, my lord. Now, since the matter has been endorsed to the ED has taken the cognizance and they have registered an investigation going on. If you see that the prayer portion, this matter perhaps become infractious, my lord. If your lordship see the prayer portion, my lord.
My lord, I may have some difficulty. There are other litigations which I'm.
Oh, then, my lord, yes.
Others.
Yes, then you.
So we'll
Various-
just appoint you today and then we'll look into the matter. Because I think this is, yes, a slightly Other matters also there concerning.
Yes,
the
if-
conflict of interest.
Yes, there is a clash of interest.
Conflict of interest
Because
would be
other
there,
matters, Public Service
You're,
Commission.
you're
Hmm.
representing.
Mr. Patil, you had suggested where is
Mr. Tony Pardon here, my lord.
Can you, this thing, assess the court as a amicus curiae in this case? You will appoint you. But maybe we can fix the next date instead of, okay, because let's.
Your
let's
Lordship,
go-
can you just have a look at the prayer portion, my lord? But
Yes,
since your
yes.
Lordship is inclined to appoint Amicus, my lord, yes?
But, yes, the amicus also, let him have a look, then in the next court date, maybe it can be disposed of also, if it is as simple as you are projecting.
But that's the prayer, my lord, only
Yes,
one
yes,
prayer.
Let the
My
new
lord.
appointed Amicus Curiae also have a look at it.
My lord.
Have some say in the matter, isn't it? Otherwise it will be difficult, yes.
We can fix it next week, madam.
Next week, yes, for this portal.
First.
The petitioner, Mr.
His-
Paigi Yangi, is it?
Pai Gadi, my lord.
Paigi Yangi has appeared in person while the respondents are duly represented. Suggesting that the amicus the amicus curiae appointed in this matter, Mr. Who was the,
Do you like him, my lord?
okay, legal aid
Lordship,
counsel.
Finance Cause Lead.
So and so, legal aid counsel,
Difficult.
D.U. Lachi, is it?
Yes.
Has not been appearing. D.U. Laji, okay, has not been appearing in this case. A number of times, and therefore this court find it fit to appoint another amicus curiae. Mr. A good name, please? Mr. I.A. Patil is the services of Mr. A. Patil is therefore.
T party, my lord, not M party, T party, Tony party, my lord.
Okay, Tony Patil is therefore taken in this case, and he shall be representing the petitioner as amicus curiae. Accordingly, list this matter
2nd May.
Second May,
2nd May.
second May. I don't know, my lord, second May will have a division bench or not?
Today is.
We'll make it 5th May. Okay.
Fifth May, no issue.
Okay. 6th, let's see the next.
Fifth
you
May,
see,
Sunday.
because if we fix it just before
But,
the last date of this bench,
Let's
then
be
we'll
on,
have no time to pass.
let's be on 2nd or 3rd. So on 6th, I have my personal difficulty.
7th,
8.
No,
any
no, this entire week I'll have my some difficulty.
13th Monday,
13, yes.
list on 13th.
13 Monday.
Yes. Oh, this is a petition, so. So the petitioner will have extra copies, I think so. Registry will not make.
You provide extra copy.
All the copies, you give it to him,
Yeah, I
of
will
your
give,
petition, no?
it is already in the
Yes.
earlier advocate here.
The registry,
What is?
yeah, the registry,
On
yes.
records, yes.
The registry is to provide
Yeah.
the relevant documents and to the learned amicus curiae by the next court date.
Okay.
6 and 7.
Yes, Your Lordship, Your Lordship can hear me. I'm appearing in item 6 for the respondents. So I have one preliminary objection regarding the maintainability of this writ appeals. Because this is the 4th round of litigation, the land acquisition award has been challenged and that has been dismissed. The appeal before the High Court has been dismissed. So if my learned friend starts, he should first address. My request is, Lordship, may I ask him to address with the maintainability part, because this is the 4th round of litigation. The award is at in finality. They have not challenged that.
This
And
is an appeal against the order of this court,
my lord.
Yes.
single
So
bench.
yes.
Single
So
bench.
that has been dismissed. If your lordship see the impugned order,
What,
that-
the order of the,
single judge.
what has been dismissed?
The dismiss is they are challenging the land acquisition process in a writ petition. So the learned single judge has specifically held that this cannot be done because the
Yes,
land acquisition
so-
right to fair
so-
compensation.
So since the learned single judge says that this cannot be done, the appeal is against the order of the learned single judge who says that this cannot
Yes.
be done, isn't it?
Yes,
So
yes,
let's
correct.
hear the submissions made by the
Correct.
appellant concerning that.
Correct.
So we will concentrate only on the
Maintainability.
uh,
Para 18 of the impugned judgment, it has been held. Para 18 of the impugned judgment.
So we'll hear the appellant
Very well,
as to
very well.
why he is aggrieved with the judgment and order passed by the learned single judge, isn't it?
My,
Hmm.
my
Confined
pleasure.
only to that.
My lord, on maintainability as well as on merit of the case, my lord, this matter may
It has been
can be
set
discussed.
aside, huh? Yes.
No, my lord, basically, this writ appeal has been prepared against the judgment and order passed by the single bench,
Hmm.
on the single bench in the connected writ petitions, my lord. Basically on my lord, limited grounds. Firstly, my lord, my lord, for acquisition of land, some certain procedure has to be followed by the acquisition authority, my lord.
Hmm.
The particular thing is the willingness certificate. The willingness certificate has to be obtained from the the requiring body, for whom the land is proposed to be acquired. And another procedure, the limb of submission is basically 4 grounds I have stated in my appeal also, First is there is no any willingness certificate from the requiring body. Third is second is no procedure has been followed. And third is no inquiry was done as per direction of this honorable court in previous round of writ petitions, and the notification issued and the connected impugned award, that is not fast as per the procedure, So, I'll come to details of the affidavit, details of the facts from annexure 1 to the annex, the all annexures, Firstly, what,
But one thing before you go ahead, we are going to only look at the judgment of the learned single
Correct.
judge. Okay. So the learned single judge has dismissed
my
your writ
writ
petition
petitions,
based on the grounds that it is not maintainability.
maintainable basically on that,
Are not
that plea
maintainable.
I have taken it bar by adjudication,
So we will look only on this point.
my lord.
We will not look into the merits of the case.
Bar by,
Because it is only against this. If
Yes.
we find that it is actually maintainable and liable to be set aside, then I think the matter will have to be referred back to the single judge, remanded back to the single judge, look into the award or your points which you have mentioned.
my lord.
So today we will look only at the judgment of the single court which says that the writ petition
Correct.
is not maintainable.
Correct.
So confine the argument only to that.
My lord, may I take your lordship to page 318, my lord, annexure 21,
180.
318 of my writ appeal. And my lord, it starts from page number 2326, my lord, same annexures 21. And my lord, I'll skip this part.
Okay, this is the order dated 08/09/2022. Yes.
My lord, findings of the honorable court, my lord, single bench is at page number, my lord, it starts from the, my lord, the page number 330, my lord. 330, my lord. Last, Malat, I'll start reading from para 16, Malat.
Okay.
The issue of limitation has also been argued along with the issue of res judicata as well as the sub judice, sub judice as well as res judicata, Madam. The issue which is arisen for determinations in the present interlocutory applications is that of the maintainability of the writ petitions, Madam. That in the connected writ petitions, they raised the by way of the interlocutory application, raised res judicata as well as res sub judice. There is no manner of dispute that the powers conferred by the Article 226 of the Constitution of India to a High Court is plenary in nature. However, what is equally important is such plenary power are to be exercised judiciously and in extraordinary circumstances wherein the issue of the equality is of equal importance. This court, by exercising the appropriate power, is court of the equity, wherein the conduct of the parties approaching the court becomes important and relevant. In the instant case, there is no manner of doubt that the following the provisions of the Act of 2013, an award was passed on 6/9/2019 by the Deputy Commissioner and Dibang Valley District. The said award being passed and published in accordance with law, if any party was agreed by the same, the step as per the law should have been taken, which was not done. And it is the land affected persons who, after have to file the writ petitions in this court in the year 2019 to get the compensation as per the award. The writ petitions were decided by hearing both the parties where the award amount was directed to be released within a time-bound frame. The Union of India had filed a separate writ appeal as indicated above. However, both the appeals were dismissed by the Honorable Division Bench, against which no further appeal has been prepared. Further, though land appeal was prepared being LA number so and so, this court, by order dated 10/12/2021, had dismissed the same as the same was not maintainable. Even the said orders of the dismissals dated 10/12/2021 has not been the questions in any appeal. After the aforesaid developments, the questions that arises is that whether the first round of litigations that has been issued by the Union of India, that too by filing 2 numbers of writ petitions with same period is maintainable, is a question mark. The aforesaid conduct of the Union of India in filings 2 numbers of the writ petitions in the year 2022 in the opinions of this court is barred by the principles of res judicata in as much age. There is a conclusive determinations of the issues in the early round of litigations in 2 writ petitions issued by the instituted by the said Union of India, who had gone up to the level of the writ appeals before the Honorable Division Bench, and the order passed in the writ appeal, they have not been put to challenge in the Honorable Supreme Court. However, the second writ petitions being number so and so is clearly barred by the principles of the res judicata, res sub judice, as the same has been filed with the same period as WPC number 190 of 2022. The another issue which arises for the determinations in the questions of the limitations, though in the writ proceedings there is no strict applicability of the Limitations Act 1963, and what is required is to be seen in the question of laches in approaching the writ court, which is a court of equity as indicated above. The Supreme Court in the case of so and so reported in the so and so has laid down that though the court would not be bound by the limitations prescribed in the Limitation Act of 1963, the court is only entitled to examine whether there is laches and inordinate delay in approaching the court, and what is barred by the Limitation Act is also required to be barred by laches insofar as exercise of the writ jurisdiction is concerned. For ready reference, A relevant paragraphs of the said aforesaid judgment is extracted here and below, my lord. My lord, I'll skip this part.
Hmm.
Now, my lord, the findings of the my lord, this is, my lord, I'll skip page number 333, and my lord, lordship may come to page number 334, my lord.
Hmm.
In view of the above facts and circumstances, and in view of the principles of the law governing the field, this court has no hesitations to come to a conclusion that the writ petitions are not maintainable. Accordingly, the instant interlocutory applications stand allowed, and the writ petitions are dismissed is not maintainable. My lord, the dismissal, my lord, lordship has already seen. By this order, my lord, merit of the case has not been decided, my lord. Only the my lord on limitation and as well as the my lord res judicata, my lord. Res judicata as well as the res subsidies. Now, my lord, by reading, my lord, this, my lord, the effect of the case is required to be, my lord, the place for clear understandings of the effects of the case, my lord. My lord, what happened? The ITVP was inducted in the state of Arunachal Pradesh in the year 2005, bordering, my lord, the border areas, to safeguard the border areas, my lord. And after induction in the state of Arunachal Pradesh in the year 2005, my lord, this piece of land, altogether, my lord, the 5 pieces of land has been, my lord, taken over from the then, my lord, erstwhile, my lord, Assam Rifle, my lord. The Assam Rifle was in the state of Arunachal Pradesh, and where, who was the actual, my lord, the possessor of this land, my lord? This land particularly belongs to the Assam Rifle. After inductions of the ITVP in the state of Arunachal Pradesh, this land has been, my lord, handed over to the ITVP, my lord, from the Assam Rifle. And Assam Rifle was in the possession of this piece of land in the year since 2062, my lord, and even before that, my lord.
Since
And-
1962,
Madam,
Assam Rifles.
madam,
When did it hand it over the matter?
madam, that specific paragraph which I have mentioned in the when madam, that handing and taking over is also given.
Okay. No, the facts of the case is different. Now, what was wrong with this judgment of the?
Madam, judgment is,
single
madam,
judge?
his lordship is, madam, aware that the principle of res judicata is something different, madam. Lordship,
So you're saying, so it's confined to that, we'll not come to the.
yes,
facts
madam.
of the case.
Now, madam, the principle of res judicata, madam,
This court says that res judicata and
res
limitation.
subjudicement.
These two-
Admittedly, at that relevant point of time, 2
Huh.
writ petitions were pending. The
Hmm.
first, this is the first one, my lord, wherein, my lord, this order has been passed. While dealing this, admittedly, my lord, it is in item number, my lord, next item, writ appeal number 42, my lord. These are analogous, madam. Second
Okay.
item, my lord,
So, the second writ petition is,
second writ petition, 210 of 2022. And same way, my lord, we file writ appeal against the order passed order passed by the, my lord, learned single judge bench
hmm,
in, my lord, the common order.
hmm.
That writ appeal is listed.
Yes, madam. Item number, my lord, 7.
So these two are being.
And, my lord, item number 7, my lord, if, my lord, if lordship interfere in this case, my lord, items.
Yes. So in one judge, it's been read together, by the single judge in this. So this is a common order for
My
both
lord,
the,
common order, ma'am.
isn't it?
0809 2022, my lord.
So let's examine the reasoning of the learned single judge.
My lord.
The reasoning made by the learned single judge, we will examine that. Okay, and see whether the reasoning as to why it was dismissed on maintainability, whether it's a reasonable reason or not. We'll have to just look at this.
In nutshell, my lord, may I make submission, my lord?
Okay,
This is the, my lord, the facts of the case.
Yes, okay,
It has,
come.
this piece of land
Yes,
has been
yes,
taken from
yes.
the Assam Rifle. My lord, when this piece of land has been, my lord, my lord, initiated for the regularization for, in favor of, my lord, this ITBP, my lord, all of a sudden, bunch of writ petitions were filed. bunch of writ petition, my lord, as this is the findings of the honorable single bench also, my lord. In that, there are a bunch of writ petitions, my lord. This honorable court has given a directions to the deputy commissioners to cause an inquiry whether this piece of land belongs to the state government or the private individual or the community land. Nothing was done. All of a sudden, my lord, the notification was issued by the, my lord, the state government for acquisition of land without following the due procedure of law. My lord, thereafter, they passed an order, award, my lord, and given the directions to the, my lord, the ITBP for releasing of the award passed by them only, my lord. And that was not within the knowledge of the ITBP, my lord.
Where's
They-
where's that order
My
of
lord,
the single judge saying that verification should be done? In which WPC?
my lord, verification, my lord, to that extent, my lord, the foray was made before this honorable court, my lord, by the single judge. When the motion itself, my lord, there was the, my
In
lord,
which WPC?
WPC number, my lord, 190 as well as 210, my lord.
190
Correct.
and 210.
My lord. Yes, ma'am.
WPC 190 and 210. The single judge had said that the district judge should make verification. Is it?
My lord, for quarry.
Inquiry should be done by the
No, my lord.
deputy commissioner.
In early round of writ petition, my lord, this is the, my lord, the
First round of WPC, what happened?
first round of writ petitions, my lord, direction, I have enclosed also, my lord.
Okay, wait. Let's just see. Let's try and understand what has been happening.
Page number, my lord, 104, my lord, annexure 4,
104.
my lord. And relevant page is, my lord, this was prepared by, my lord, Gita Mehu, one Gita Mehu, read WPC number 104, my lord, I'm reading WPC number 11 of 2017, my lord.
Okay.
Prepared by them,
First
my
round
lord.
of litigation
Yes.
happened in
And relevant
WPC.
page is 106, my lord.
106.
6, my lord. Third, fourth paragraph, my lord. Married, my lord.
Yes.
In such view of the matter, this court, this writ petition is disposed of with the directions to the deputy commissioner, the Debang Valley would cause an inquiry and as certain as to whether the land in the questions involved in this writ petition is a community land of the petitioner or it is a government land. In causing the inquiry, the deputy commissioner would also the consult the revenue record pertaining to the land from prior to 1955, my lord. And it is also stated earlier, it is stated there, earlier this plot of land was a part of the erstwhile, my lord, this Lohit district. And after the bifurcation, now it is the part of the lower Dibang Valley district, my lord. In such view of the matter, the deputy commissioner, if requires, may also requisitions the land record that may be available in the office of the deputy commissioner Lohit districts to arrive at a proper assessment regarding the ownerships of the land and which conducting the inquiry. While conducting the inquiry, the deputy commissioners will also give the writ petitioners or his representative an appropriate opportunity of being heard in order to present his case that this land is a community land of the petitioner. While giving the opportunity, the deputy commissioner should also allow the writ petitioners to provide any evidence and materials that he desires to produce in order to establish the claims that this land is a community land of the petitioner. The aforesaid exercise be carried out within a period of 6 months from the date of the receipt of the certified copy of the this order, madam. Just for a moment, madam, I'll force the in the affidavit, madam, there is no way, madam, in the even statement, the affidavit filed by the state respondent, there is no evidence to show that in compliance of this order, madam, inquiry was caused, and the madam, after determinations of the madam, everything's madam, this has been decided that this particular piece of land belongs to the community land of the petitioner or the government land. There is no such nothing on record, my lord.
Okay, anyway.
Yes.
So this is the first writ petition
Filed by them,
by one of the landowners.
landowners, ma'am.
Okay.
And
fine.
nothing was done.
So there was no appeal against this. This is accepted.
Yes, my lord.
Okay. After that, what happened?
After that, my lord, without my lord, taking consent from the my lord, the requiring body, that is me, my lord, the IDVP, my lord. The state government, my lord, published the impute notification, my lord.
Okay, then notification was,
My lord, impute notification past two altogether, my lord, two notifications were published, but out of that one was given effect, my lord. Impute notification. First one was cancelled. Page number, lordship, 166, annexer 8, my lord. 166, my lord. This is the second notification, my lord, issued by the state respondent for this piece of land, my lord. Altogether, 4 pockets of land. It was published on, my lord, 24th April 2018, my lord.
18.
And the land is specifically serial number 1, Alinea, serial number 2, Malad Dambian, and the 3, Malad 3 is Malinia, and 4 is Malad, serial number 4 is Malad 4th one is Malad Mipi, Malad. And specific description of the areas is also given, Malad. Malad,
Okay,
as
so
per the procedure,
publication,
Malad,
yes.
before publication of this notification, there is a procedure contemplated under wherein, Malad, the willingness certificate has to be obtained from the requiring body, Malad.
Where's that?
Just for a moment, may I take your lordship to the rules? Right to fair compensation, my lord.
Yes.
It is rule, my lord. Right to fair compensations and the transparency in the land acquisition and rehabilitations, my lord.
As per rule, how much rule?
Rule 3 of,
3.
my lord. In short, my lord, rule 3,
Yes.
rule
Where is
3
it?
of,
Only one copy we have? Oh,
my lord, rule 3.
2014 rule.
Right
yes.
to fair compensation and transparency in land acquisition, rehabilitation and the resettlement within bracket, my lord, compensation, rehabilitation and settlement
Yes,
and
yes,
development plan.
So,
My lord.
rule 3.
Rule 3, my lord.
Oh.
Married rule 3. Request for land acquisition, my lord. My lord. That's why, my lord, I'm submitting that, my lord, the rule
So
3, my lord. I'm
impact
reading.
assessment consent rules. Which rule are you reading?
My lord, it must be in page number, my lord. If I'm lordship is having the same, my lord, copy. It is in page number
2012.
83,
Yes.
my lord.
Page?
83, my lord.
Okay, 83. Yes, yes.
If
yes.
same book is of the publication
see,
of
let's see.
Universal, my lord.
Page 83.
Very recommended. Yes, page 83.
Compensation for rehabilitation
Correct,
and
ma'am.
resettlement. Okay, this one. Yes.
I'm reading rule 3, my lord, chapter
Yes.
2.
Yes.
Chapter 2, a request for land acquisition, my lord. And rule 3, my lord. Request for acquisitions of land, my lord. After completion of social impact, my lord, there are several procedures before publication of notification, my lord. After completion of the social impact, the assessment, the wherever applicable at the receipt of the recommendations of the expert group, if it appears to be the appropriate government that the land in any area is required or likely to be required, or any public's proposed, the requiring body or its authorized representative for whom the land is to be acquired, my lord. For us, the land is going to be acquired, my lord, shall file the request to the concerned collectors in form 1, along with the following documents, namely, my lord. These are the, my lord, details, my lord.
Okay, so you're saying that rule 3 was not followed
Correctly, my lord.
at the time the
Yes,
notification
ma'am.
was issued.
My lord, just for a moment, my lord. Again, may I take your lordships to how this has been substantiated by the state government while, my lord, is issuing notification, my lord. May I take your lordships to the same affidavit, my lord, in the connected read petitions, wherein, my lord, the state respondent has clearly stated that no such procedure was followed. Just for a moment, my lord, may I take your lordships to the affidavit filed by the state respondent in connected read petition, my lord. Affidavit filed by the, my lord, the state respondent, my lord. Sorry, my lord,
My learned friend is reading from the second read petition. Is it the read appeal, second read appeal?
Annexure 19, my lord.
Page,
Page number, my lord, 231, my lord.
231 of the second read appeal. So item 7.
this is the first one. We're still dealing
First
with
one.
the first one. 231.
My lord, just for a moment, my lord, may I take your lordship to the relevant paragraph wherein, my lord, categorically, my lord, it starts from page number 231, sorry, my lord. Page number 231, my lord. This is the same affidavit filed by the state respondent in connected, my lord, the read proceedings, my lord. It was
Since
filed.
the Union of India has come on and on again before this court, let's hear him out and see what is the reason.
My lord, the
Isn't it?
reason is.
Yes,
Admit,
so you're explaining the reason, yes.
my lord, the reason is admittedly, my lord,
Hmm.
we were all together, my lord, in the entire proceedings, my lord, in the wrong forum, my lord. Wrong forum, my lord. Because of that, my lord, no determination has been made. Therefore, my lord, I made a submission before this honorable court on the last occasion also, my lord, that this section 11 of the CPC will not govern us as because my lord, the determination has not been done.
Yes.
So principle of the res judicata, my lord, is not applicable in our
Okay.
case, my lord.
Yes.
That is the
yes.
simple, my lord, my submission. Had it be the case that, my lord, if this honorable court address the entire things and decide the case of the merits on its own merit, my lord, if determination is done, my lord, I could.
So we'll see
Be hit
whether
by-
the principles of res judicata will be applicable by hearing you out. Yes, so
Correct,
please
ma'am.
go ahead.
Correct, my lord.
231.
231, my lord, just for a moment, my lord, may I take your lordships to page number 233, my lord. 233, my lord, para 4.
Yes.
Normal, my lord. Merit, my lord.
Hmm.
This is the, my lord, the affidavit filed by the state respondent in 211. Para 4, my lord. I'm reading, my lord. That with regard to the statement made in para 3, 4, so and so of the read.
No, this is in
Same connected, my lord.
211.
Yes, my lord.
Writ petition 211.
211 in item number 7, my lord.
Okay, okay. Hmm. This is item number 7, but we are dealing with item number 6.
6.
Isn't it? So, WA in item number 6 is against which petition what?
Or else, my lord,
Anyway, since the matters have
my
been
lord,
considered
this is the item
together.
number 7, my lord, connected all, my lord, it is in same location, my lord, same district,
Okay.
same authority.
Oh, okay. Yes, please.
Para 4, my lord.
Hmm.
In this, in regards to so and so, para so and so, the answering respondents humbly begs to state that going by the previous record from 2000, my lord, 6 to 2016, and a series of the communications between the deputy commissioner and the ITBP, admittedly this DC asked the ITBP to deposit the land revenue at the rate of 10 Rs 10 per square meters, amounting to Rs 1,71,955 for 17,195.5 square meters at MIPI, 11,77,310 for 1,17,331 square meters at Anini, Malan. Altogether, Malan, 4 pockets, Malan. I'll skip this part. Next page, Malan. Malan, I'm reading at Dambian and RS so and so meters at Italian, Malan. As one-time land revenue in the year 2008, Malan. I am directed to deposit this much of amount is one-time revenue in the year 2000. The ITPP got the sanction, got its sanctions from the Directorate General ITPP in the year 2016, initiated in the year 2008 and got sanctioned in the year 2016. It is pertinent to mention the hearings that the private respondent herein claiming to have interest in the land in the year 2017 by approaching this honorable court by numbers, read petition number so and so, this is the same things which Lordship has already seen in the one of the read petition, wherein this honorable High Court taking cognizance have directed the DCs to determine the ownership of the land first. The land for which the award was prepared is more than the land acquired and the handed over by the Assam Rifles, which was vehemently objected by the ITBP on the ground that for acquiring more than that required, it is mandatory to obtain willingness certificate from the requiring authority, in absence of which the land acquisition process was void of an issue. This is the same things wherein notification was issued. The state government was directed to file an affidavit clarifying the extent of the state government, and by way of this affidavit, this has been extended. No procedure has been followed, and the land acquisition process was void of an issue. Next paragraph, Para 15, sorry, para 5, same page, I'll skip the humble, third line, humble deponent begs to state that there was some errors in the land acquisition process. The DC, without obtaining the willingness certificate, requisitions from the requiring body, has passed the award on his own. And the state government is now saying that no, the acquisition, everything has been done in procedural violation, and award has been passed by him of his own. Now this affidavit is very much clear. More so, there is difference in the area of the land. I am reading page number 235, same annexures. More so, there is difference in the area of the land handed over to the ITBP by the Assam Rifles and to be acquired as per the award, which signifies that the acquisition process was carried out properly. No, acquisition process was not carried out properly. This is the clear stance of the state government. Now they cannot take another different stance. That procedural is followed, everything has been done as by way of affidavit. Therefore, this is the same thing, same reason by the honorable division bench, single bench has not addressed on merit.
But I just this thing, but this 211, WPC 211,
Yes, ma'am.
it was decided in favor of the respondents. This thing was dismissed, isn't it?
Correct, ma'am.
By,
Despite these steps taken by the state government, madam.
so on what grounds was it dismissed?
Dismiss is, madam, because of the res judicata, because of the principles of res subsidize, madam. As our lordship has already said.
Okay, they
Yes.
didn't dismiss it. Okay. Thanks.
Madam, honorable division bench admittedly, madam, has not gone into the merit of the case, madam.
Yes.
Madam, admittedly, honorable division single bench has not gone into merit of the case while madam dismissing my two read petitions, madam.
331. So the same issue has been discussed, it has been discussed, isn't it? Oh.
This has not been reflected at all, madam.
Your point has not been reflected.
Correct.
But
On filing of the
But,
interlocutory
but,
application,
you're saying this was not reflected and it was dismissed.
correct, madam,
Is it by the,
without going into the merit of the case, madam. Only on two grounds. First is principle of res subsidize, and the principle of res sub judicature. My lord, my limited understanding is it is not applicable in my case. My
Okay. This is 2022. But then it had come before the division bench, isn't it?
my lord, therefore, my lord, the facts is little bit required for my lord, clear understanding of the fact. My lord, I'll come to that part also. My lord, two writ petitions.
Oh.
Two
Two
writ
writ
petition was
petitions
filed by
was
them, my lord.
Hmm.
After first round of writ petition in the year 2017, again they came before this honorable court in the year 2019 in two writ petitions. And two
Numbers,
writ petitions
writ
was allowed,
petitions, number
281, madam,
281. What? 281.
281, madam.
281, WPC 281 of
Of,
2019
2019, madam.
29
and 274 of 2019.
Correct, madam.
274 2000.
These two are also dismissed.
No, this was allowed.
So, I'm sorry,
And
this was
this
filed
was
by us,
allowed,
it was
madam.
allowed.
Allowed in favor of the petitioners,
Correct,
isn't
madam.
it?
Then against that,
Land
madam,
acquisition.
that against that, madam, order, madam, being agreed by the order of the, madam, the order in that, we went to the, madam, the madam, the division bench, madam.
So division bench dismissed.
Division bench, madam, that is the, madam, the core issue, one of the core issue. Division bench has, madam, simply, madam, dismissed, giving us a liberty to approach before the appropriate forum, madam.
Appeal.
Appropriate forum, madam.
Appeal, because there is an appeal provided under the statute.
Madam.
And against that order, you also file an
Correct,
SLP.
madam. No, madam.
No.
No, we have not, madam, taken the judicial recourse, madam. Thereafter, madam, this 190 and 211 writ petition was filed before this honorable court. Madam,
Anyway,
there is a,
division
madam,
bench,
there is a admittedly wrong interpretations of the statutes, madam. We were in the altogether, madam, the wrong forum, madam. On the first round of writ petitions, madam,
8.
I think this court has, the single judge has referred to all that in its judgment, isn't it?
Yes, Your Addition.
Yes. Yes.
All
yes.
details have been mentioned.
It's been mentioned
Yes.
in the judgments of the single bench.
madam, the fact, short facts is reflected, madam.
It's reflected.
They also went to Supreme Court also. SLP also was dismissed.
If
Madam, discussion is something, madam, it is in other aspect, madam.
Yes, Mr. Secretary.
Madam, may I clarify the factual aspect, madam? Madam, I have submitted one list of, madam, dates with the relevant, madam, orders of all the proceedings of this honorable court, madam. I am appealing for the respondents, madam.
Written arguments.
Not written argument, madam.
My lord, that
A
written
list of
argument has
date-
been filed by me. That written argument, your
A
lordship,
list
is
of
filed
date,
by
madam,
me.
contain a list of date, madam, containing all the orders passed by this honorable court and the Supreme Court in connection with this matter, madam.
Where is that?
Where is it?
Madam, I have submitted there, madam.
There is only a written argument which is submitted on behalf of the landowners.
Yes, I am appearing in that. I have filed this.
You have filed your written
Yes,
argument.
page 4 of that written argument. I'll just quickly, 5 minutes, I will
No,
just.
but
one
what
second.
about what you have submitted? On which date?
Madam, one list of date, madam,
List of dates.
containing all the judgments, orders.
Madam, since we are dealing on the, madam, the issues regarding, madam, res judicata, madam.
Madam, kindly,
Yes,
if
res-
May I
I have
kindly,
an extra copy, madam.
madam, how res judicata is not applicable, principle of res judicata is not applicable in this case, madam, madam, will be clear from the, madam, order passed by the division bench, madam. I have annexed also, madam.
Madam, another
Page-
copy is also available, madam.
Page 266, madam.
Madam, may, madam?
Wait,
Just-
let him finish that. Now, this we have just seen today.
No, it's only list of dates, my lord, containing all the orders passed by this honorable court and by the division bench and by the Supreme Court, my lord. Just to clarify the matter, my lord.
This matter has come.
Detailed
before the
hearing
court
is
many
required
times.
to be
Yes,
required
madam.
in this case, my lord, is because from facts of the case, my lord, it will be
See.
clarified, my lord.
Your point, your main point is that the rule 3, I think para 3 of the rule
Correct,
has not been followed
Followed.
initially. Okay, and admitted.
my lord.
Now, whether those issues, whether rule 3 has been followed or not, has been addressed by the subsequent writ petitions that were filed,
It is in.
the judgments.
In the
We have
read petition
seen that
number,
also.
madam, read
Isn't
petition,
it? Are you getting my point?
Yes, yes, I'm getting.
So his main issue is that rule 3 was not followed
correct, madam.
as per the first judgment of this court, 2017. And then the matter has been going on and that issue has never been addressed. That's his point. So he said that it cannot be res judicata because that main point, rule 3, has never been addressed by the courts in the many litigations that has been
Correct.
going on.
But it was never raised in the earlier writ petitions, my lord.
So whether it was raised or not, that we'll have to see because you had filed your writ petitions, your petitions. So
So
we'll
this
have to
is-
see your prayer, whether what was actually going on and
Yes,
whether
ma'am.
this issue, whether rule 3 was addressed to or not in the previous court's dates. We have to see. I think that's a main.
My lord,
concern.
in our two connected read petitions, my lord,
In your writ
my lord,
petitions.
we raised in that issue. We have taken that plea that procedure was not followed by deputy commissioner and as well as the state government of their own. My lord, issued the notifications for acquisition of land in favor of me, admittedly, but no
But you did not
procedure.
appeal. Did you file an appeal against that, the writ petitions?
Notifications, no, madam. That notification we came to know only when the first round of writ petitions was filed before this honorable court in the year 2019 only, madam. And
That is not
therefore, my
correct.
lord, we
That is not
prepared
a
an
correct
appeal.
statement.
So when you got to know about it in 2019,
19
then what happened?
Then 2000 writ proceedings, 2019, my lord, the writ petitions filed by them went in favor of them.
Yes. in
Against
favor.
that, my lord, being agreed by the order passed by the honorable, this honorable court. My lord, we prepared an appeal before the division bench, my lord, at principal chief.
Yes.
My lord, his
Which was
lordship, the chief
Which was
justice,
dismissed.
it was dismissed, my lord, dismissed by observing, my lord,
Proper forum.
correct, my lord.
So you had to go to the proper, when you went to the proper forum,
Proper forum
it was
is,
not the proper forum again.
my lord, proper forum is, therefore, my lord, there is a, my lord, to my limited, there is a misnomers on the part of the, my lord, the interpretations of the, my lord, the statute. Admittedly, my lord. Why, my lord, how this was, my lord, wrongly initiated, my lord.
Section
My lord, if-
74.
No, my lord. That is the, my lord, the mistakes we have done in entire this proceedings, my lord. If, my lord, the notification has been issued by the state government without taking the consent from the, my lord, the requiring body, my lord, the remedy is, if award is passed, the remedy is, my lord, only before this honorable court. Had it been the case that, my lord, we were the interested party, my lord, we could have made an appeal before the, my lord, the district judge by section exercising, my lord, section 70, that no, we are not satisfied with the, my lord, the determination arrived by the, my lord, the district collectors regarding the compensation, my lord, regarding the, my lord, the calculations of the amount. My lord. Then only provisions, my lord, section 70 will
So
applicable.
it's not the calculation
Well,
of the amount, it is a
when-
procedure.
Where the requiring body, as per the definition is provided under the said Act 2013. Provision is, if the notification has been issued not as per the procedure, if the anything has been done by the state respondent of their own, only remedy is before this honorable court. Therefore, after long the proceedings, we came before this honorable court afresh, wherein by that time it already late that. Therefore, my lord, honorable single bench has observed the conduct of the Union of India is not correct, is because you were altogether in the wrong forum, my lord, after 2000, my lord, dismissal of the entire thing, my lord, this present writ petition was initiated. This was the observation. So therefore, there is no wrong, there is no harm, there is no, my lord, the otherwise, lawful impediment on the part of the Union of India for my lord approaching before this honorable court by way of my lord exercising under 226 my lord.
Now,
Of course, there is a my lord, there is a provision, my lord.
Okay, so
By my lord,
Your Lordship,
by the act of the my lord, the Union of India, that cannot be my lord,
I'm getting, I
barred.
think we are getting the point. So.
Your Lordship, may I just point out on the
Let me
merit
continue.
also what has been submitted by the learned friend? That is not correct. He was
On the
aware of
last
the award.
occasion,
He
my lord, I took
participated.
1
He
2 hours
participated
10
in the
minutes
proceedings.
to
He
complete
never
my
objected.
argument.
After
Unfortunately, my
1
lord,
year,
the conclusion was not my lord, given. So it was only my lord, on the part of the my lord, the arguments to be advanced by the my lord, the state respondents, my lord, that stays the matter
kindly,
was my lord,
Your Lordship, kindly at page
the adjourn.
174.
Now,
The matter was adjourned. It was part heard, is it?
no, exactly not. No.
Not.
It was heard by His Lordship, Honorable Justice N. Tagia before his transfers to the Patna High Court. My lord.
My lord, it has been pending for the last more than 1.5 years.
Anyways, so let's, yes, you can
Yes,
continue.
His Lordship was the first
page
my lord,
174.
my
Page
lord, first,
174. I will just
who my
refer
lord,
to that.
the exhaustively heard the matter. On that day, my lord, I took 2 minutes. My lord, it is still in the records, in the video record, my lord. I have taken out also, saved in my lord, the.
My lord was very correct, my
To-
lord, while pointing out at the very initial stage.
Anyways,
So, subject to my lord, the convenience of your lordships, my lord, may I afraid it, my lord, this matter may be disposed of, is because on the several occasions, my lord, this matter has been, on the last occasion also, counsel for the other party has made submission before this honorable court that I took, my lord, altogether 11 to 12 times adjournment, my lord. Not exactly correct, my lord. However, my lord, I'm ready to dispose of, my lord, if, my lord, the facts of the, my lord, the case is requires to be understood correctly so as to arrive at the correct decision, my lord. This is the, my lord, one aspect wherein, my lord, facts of the case is required to be, my lord, heard first.
My lord, your Ladyship will permit me
so
to
basically,
say something.
we'll have to look into the other WPCs, which were also disposed of, and the nature in which they were disposed of, and the writ appeal, which was dismissed, the nature in which it was disposed of, and your points in the writ appeals, whether this point, Rule 3, okay, a para 3 or Rule 3,
Rule 3.
has been discussed or not.
Yes.
If this, your first point, that is Rule 3, has already been extensively discussed,
Correct.
then the principle
Exactly,
of
Malan.
res
Admittedly,
judicata
Malan.
will be applicable.
I'm Malan,
Okay.
truly Malan, appreciated is because Malan, this is the only core issue, Malan. How the Malan, the principle of res judicata will be applicable in my case if Malan,
If that
correctly,
point were discussed and
Rule
disposed
3
of,
is Malan,
isn't
discussed with. Malan, determination has been done. Malan, everything has been adjudicated as per the Malan, the merit of the case. Malan, the principle of res judicata will not hit in my case.
in the judgment of the single bench, he has discussed, the learned court has discussed the
Again, page 326, Malan. Already we have seen
we have read, but
the ground of rejection. It is not on merit, Malan.
but we'll have to now look into all the judgments, previous judgments,
It starts from page number 326, Malan, and extra 21. Malan.
and whether those points were really explained by this court. Isn't it? And what was your submission before the court in the WPC? Whether you had raised this issue or not. In your WPC,
190 and 211, Malan.
so in 190,
First writ petition is 190 and
yes, so
second
in
is
190,
211, Malan.
the learned court did not really look into the merits of the case because
Correct, Malan.
because of the disposed of matter. Yes, so you'll have to do your homework
My-
extensively.
So therefore, my lord, this is the
So
only
let's-
reason.
Let's look at the judgment of the learned single judge, para to para, to see whether what was actually discussed
Correct.
there. And then we'll go back to the WPCs, previous WPCs. I
Correct.
think that will be more appropriate. So that we don't get confused, because this case has a past history, isn't it?
My lord, admittedly, this is the only, my lord, on the several occasions, my lord, this is the reason, my lord, matter is, the matter is kept on adjournment, my lord. So, my lord, otherwise, we are ready, my lord, for this puzzle, my lord. So therefore, my lord, my effects of the, starting from the annexure 1 to last annexures, my lord, will be required, my lord. That's because from that facts, my lord, everything will be gathered, my lord. My lord, my humble submission before your lordship is, while dismissing my writ petitions, two writ petitions by common order 8/9/2022, my lord, core issue has not been addressed. Only on the merit, my lord, the delay and laces, my lord. Principle of res judicata as well, my lord.
Okay, let's come to page 326,
Three-
para 4.
326, my lord. Yes, my lord. The subject matter is regards to the accusations of
Wait,
delay.
we don't have to read the whole thing. Now, there are these two WPCs mentioned,
It is the first writ petition,
274 and 281.
81,
Okay.
prepared
Now,
by
in
the
this
man.
274 and 281,
Correct,
you
ma'am.
were the respondent.
Correct, ma'am.
Okay. When you were the respondent in this, when you filed your counter affidavit, did you mention that para 3 of
Rule 3. Yes, my lord.
Rule 3
That,
of
my
the
lord,
rules were
not-
not,
My lord,
yes.
to make
followed.
fair submission,
So
not-
was that point discussed
my
in this?
fair, to make fair submission, my lord. Correctly, that has not been addressed. Correctly, that has not been addressed, my lord. At that relevant point of time, my lord, we were on the, my lord, the merit of the case. So therefore, my lord, that has been, my lord, if records is called for, my lord, then admittedly, my lord, the affidavit filed by the, my lord, the Union of India through ITBP, my lord, that particular thing has not been, my lord, addressed. Admittedly, my lord.
In your counter also.
Yes, ma'am.
And then when you went on appeal, when you
Yes.
appealed against this,
Yes.
now then did you point out that Rule 3 was not followed? Then
Never pointed
Then
out.
therefore, my lord, liberty was given to raise the my lord, to approach before the appropriate forum, my lord. That writ appeal, my lord.
yes, so in the appropriate forum,
Appropriate forum, madam.
supposedly appropriate forum,
Correct,
it
ma'am.
was also dismissed,
Correct.
I think, because it was not
Writ
appropriate.
appeal is, my lord, I have enclosed the, annexed a copy of the writ, the order passed in that writ appeal, my lord.
Huh.
It's
If-
expected 3 to
Yes.
264, my lord.
This is the order. Liberty.
So in the writ appeal
Correct, ma'am.
against the said initial WPCs,
274 and 281, madam.
so is that matter addressed in para 6
Yes.
of 2 3
Expected in
so
para
yes, yes.
Yes, ma'am.
The relevant portion of the appellate court's order is at para 6, correct?
Correct.
So
Again,
nothing was addressed here.
Yes, ma'am.
Merits was not discussed.
Not discussed. So
Now,
therefore,
in your writ appeal, did you mention about Rule 3 not being followed?
You have to
present
raise it, my lord.
writ appeal,
No,
ma'am.
no, in the previous writ appeal, where it was dismissed. The writ appeal, para 6, it says writ appeal is dismissed
in WA
as
196.
withdrawal.
The writ appeal 196 of 21.
They have never
But
raised
was
it,
not
my lord.
discussed.
Not discussed. Therefore, my
So
liberty
we-
was given, my lord.
That point was not discussed. Then after it was, yes, so after the writ appeal was discussed, what did you do? Then you went on an LA appeal, isn't it?
Correct.
Yes, ma'am.
And that is.
Now, yes, so in para 7 in the LA appeal, what happened? How was it?
Not in the.
appeal was also dismissed, my lord.
Dismissed, but his point.
60 days.
So this LA appeal, did you go and appeal against this?
Yes, correct. Right.
Hmm.
No appeal was filed.
As I have pointed out, my lord,
Again,
even
it was
LA appeal
dismissed.
is not correct proceeding, was not correct proceeding.
It was not
Nowhere the-
correct proceeding, but you went anyways.
Wrongly went, admittedly, my lord.
They should have challenged that
You
order.
have gone then.
Yes, my lord.
See,
Pursuing
By
a wrong
exhaust-
forum,
now how can you correct your
pursuing a
mistakes
wrong
now?
forum, my lord, doesn't, my lord, condone their laces, my lord.
Oh,
No, my lord, we have taken judicial recourse, my lord, it is of course on the wrong forum, my lord. However, my lord, we are not, my lord, keeping silence the issue. We, my lord, taken judicial recourse time and again to address the issues
so,
of very.
in para 9, okay, in para 9, when you went and appeal, here it says that the validity of the vote was not put in challenge.
Validity of, my lord,
The vote, para 9.
my lord,
329.
validity of the award cannot be challenged as because we were in the wrong forum, my lord, as I have already pointed out, section
This is the
17.
division bench, DB, which says that validity of the award was not challenged, was not put to challenge.
Yes, my lord. In read proceedings, my lord, in 274 and 218, we were the respondents, my lord. We cannot take hesitate, my lord, against the award passed by the, my lord.
So it was the procedure which you had challenged.
Yes, my lord.
So the observation of the division bench, that since the validity, did you go on appeal against the decision of the division bench then, DB?
No,
Dated 06/06/2020.
never. That retained finality. They went in the
Yes, my
LA
lord.
appeal.
This
You
is
went?
therefore, my lord. Therefore, my lord, since my lord, as lordship has seen in just above para 1, 2, 3, my lord, it has been submitted that
So let's see.
it has been submitted that I am reading, my lord, 264, my lord. It is submitted that the appellants.
264, wait,
Yes,
page 264.
correct. my lord. This is the, my lord, the division bench order in earlier round of writ, which is 274 and 281, my lord.
No, all this has been addressed by the single judge in the judgment which you are appealing against, okay? So if you come to page 329, just come to 329,
329, my lord.
para 9,
329, my lord. Para 9, my lord. The division bench, however, by the order dated 6/6/2000, my lord, it is in page number, my lord, 262, my lord.
had dismissed the appeal.
Dismiss the appeal with the observations that since the validity of the award was not put to challenge, there was no reasons to interfere with the aforesaid 7/11/2019.
Oh.
My lord,
So this observation made.
This
if
is the
you were
observation, ma'am.
unhappy with that, have you gone and challenged?
my lord, to just clarify this
Yes.
particular paragraph, again, may I take your lordships to the original order dated 6/6/2000, my lord, 6/6/2022, madam. Page number
Okay.
64, madam.
So you're saying this observation, para 9 is not correct.
Correct. ma'am.
Okay, then let's see page. Page?
264. 264. 264. This will be clarified by the this particular paragraph 9, man.
Hmm. Yes.
In this appeal, the appellant has challenged the order dated 7/11/2019 by the which the single judge directed the respondent authorities to deposit the award amount in the office of the deputy commissioner in Dibang Valley within a period of 3 months from today, on which on such deposit, the deputy commissioner is to take necessary steps to release the same to the petitioners in accordance with law. And after proper identifications, the learned single judge did not find the merit in the submissions advanced by the authorities in the seeking to find fault with the award as regards the legality and validity manner. This is the manner aspect. The learned single judge has also made the observations that, however, no effort was made by the authorities to challenge the same before the appropriate appellate forum. And it has been submitted there. The appellants are proposing to approach the competent forum to challenge the validity and legality of the award manner. We express no opinion, my lord. Particular observation. It was my lord passed by his lordship, my lord, and the then chief justice, my lord. express no opinion is, it is for the appellants to challenge the award before the competent authority in accordance with law, my lord. Since the validity of the award has not been put to challenge, we find no reasons to interfere with the learned single judge direction as on date. With the above, we close the appeal, my lord.
So what did you do then?
After this order, my lord, we file
Where did you go? Huh?
read petition number 190 as well as 211 is the option, my lord, only wherein my lord, the being agreed by the order award passed by the district collector as well as the notification 226 is the only, my lord, the provisions. Therefore, we exhausted that provision, and while filing at that affidavit, my lord, the read petitions, affidavits from the state respondent were sought for, wherein they admitted that no procedure was followed. And my lord, without addressing that part, my lord, admittedly, with due respect, my lord, that has not been addressed by the honorable single bench. Lordship has already seen the impugn order. That is the, my lord, crux of the case, my lord. Only, my lord, on technical part, two grounds, my lord, grounds for the rejection, my lord, dismissals of the two read petition is, my lord, one is principle of res sub judice, one is principle of res judicata. But, my lord, as time and again, my lord, I have pointed out, this case, my lord, this is not, my lord, applicable in my case, my lord. In this present proceeding, my lord. Had it been the case, then, my lord, in entire proceedings, in one of the, my lord, the proceedings, if, my lord, the entire thing has been determined, adjudicated on its own merit, my lord, admittedly, my lord, my case will be hit by section 17, section 11 CPC, my lord. Nowhere, my lord, merit were discussed. And, my lord, another,
In the present writ petition, where have you pleaded this point that you are arguing about Rule 3? Where
Rule
have you
3, my
taken that in the writ petition? Which paragraph?
my lord, admittedly, copy of the writ petition is not annexed along with only judgment copy, my lord.
But
Then we
where
have
have
to
you
see
taken that? Because you are now trying to say that that issue
Correct, my lord.
has not been adjudicated by this court
Correct, my lord.
earlier, and that is why the principles of res judicata is not applicable. Then you have to show us.
My lord, in that, admittedly, my lord, in that case, my lord, it will be available in my read petition to 190 as well as 211 of 2022, my lord.
Then we'll have to see that.
It is,
Isn't
my lord, there, my lord. We have pleaded that ground also, my lord.
My lord, before that,
But that has
Lordship
not
may
been,
hear
my
me
lord,
for
reflected
5
in
minutes.
the impugn judgment.
Before that, your Lordship may hear me for 5 minutes.
Then we'll have to see. Then we'll have to see whether the principles of res judicata actually applies in this.
My lord, for applicability of
My
principle
lord,
of
your
res
Lordship may
judicata,
hear
my
me
lord,
for 5
if
minutes.
the entire order passed by the, my lord, the entire order passed
The
by the,
merits
this
has been discussed.
various
and the
order
same
passed by
thing
the, my
has
lord,
come again
yes,
before the court.
that will be,
Isn't
my
it?
lord, clarified, my lord.
Your
That's
Lordship may
the
hear me for
evidence.
5
So
minutes
far,
before adjourning
in
the
none of the, my
matter.
lord, the order passed by this honorable court, as well as the, my lord, the order passed in the principal seat, nowhere, my lord, merit has been discussed.
So
Your
now
Lordship has just.
you're the counsels for the respondents.
Yes, yes.
Now we
Uh,
have heard his submission.
Yes. I'm
Okay.
just
He's
making.
trying to point out before the court that the principle of res judicata does not apply here because the main issue which he has been trying to raise before the court has
Right.
itself not been discussed at all.
Right.
Isn't it?
Right.
So to see whether he had approached this court on the point that Rule 3 was not followed as per the first decision of this court, that is 2017, we'll have to
Correct.
look into that matter.
Then, my lord, that
So
aspect,
the
my
writ-
lord,
Yes.
May I just address this?
can be verified from the grounds taken by the appellant in the memo of the appeal, my
No,
lord.
we are not concerned with the appeal memo.
Right.
The writ petition.
Correct.
Writ
itself has to be-
petition has to be looked into, isn't
If,
it?
my lord, read petition 190 and 211, 2019 is called for, everything is clear.
So now.
Your Ladyship,
we can
may I
call
just
for that
address?
into
May I just say something?
Or
Lordship, may I just say something before your Lordship
because this
adjourns the
bench will be
matter?
there only during this week.
My lord, so as to dispose of the matter, my lord, may I pray this matter will be listed.
Your Ladyship, may I
Copy of the
just
writ
mention?
petition You have filed a writ petition.
My lord. I'm sorry, my lord, today I'm not having with my lord.
Yes, you see, one
Or else,
case-
my lord, the record may be called for, my lord. It must be available, my lord.
No, no, we will
I'm
place
sorry,
it
madam,
on
I
Court
record.
is going to sit for 2-3 more, this bench, it's okay, but in single matters, we have CABs pending.
Your ladyship, may I just say
And
something?
whether the crux of the case we have understood, I think. It's a simple, if we can satisfy the court, then the main thing will be, if we find that principle of res judicata is not applicable, then the only thing that can be done in this case is refer the matter back to the single bench
Well-
to look into by the discussing the merits. Okay, that is the only thing that can be
Well-
done.
That will also, my lord,
My lord,
my lord, suffice the, my lord,
Because we're not
my
going
lord,
to
justice,
decide
my lord.
beyond that. Yes, yes,
That
yes.
will also suffice the justice as because, my
Your
lord,
ladyship, can your
if in the
ladyship
case,
hear
my lord,
me?
But we
that
have
is-
to see whether the principles of res judicata, okay, is applicable in the instant
Mic on,
case
mic
or
on.
not. Yes.
My respectful submission is there, my lord. If my lord holds there, my lord, there is no res judicata, my lord, then my lord, question will be, my lord, whether the judgment rendered by the first round of the in the writ petitions, my lord, there whereby
2017.
it has been directed that, my lord, the compensation has to be paid in terms of the award, my lord.
Mhm.
And they went to division bench. Bench has dismissed the matter, my lord. And, my lord, they have not pursued before the Supreme Court by filing SLP, my lord. Instead, my lord, they filed and, my lord, LA appeal under section 74 of the Act, my
Whether
lord.
that has attained finality. That
Yes,
is what
that
has
is
been
the,
said.
it has already
We've
attained the
understood
finality,
that.
my lord. And to my respectful submission, my lord, that order of the judgment of the learned single judge cannot be, my lord, unsettled by
Reopened again.
reopened, my lord,
Very
at this stage, my lord.
All right.
my lord,
Finality.
we are on the initial, my lord, the proceedings, the notification by which award was passed. And by that virtue of that award, my lord, writ petition, my lord,
You could
274.
have taken that point in the first round of writ petition. You were a party there. Admittedly, you have stated before this court that that point was not addressed in your counter affidavit. You have said that.
Base recourse would have been, my lord, to my respectful
Your
submission.
lordship, may I say something?
They could have, if they
May I
have
say
not
something?
filed a SLP, my lord, they could have come
The
for the,
proceeding has already attained finality.
yes, my lord.
The finality is, my lord, giving the.
Anyway, we will consider all
And,
the
my lord,
arguments.
and also, my lord, just for, my lord, I am submitting, my lord, pursuant to my lord, later on, they filed an SLP before the Supreme Court. And in terms of the direction made by the Supreme Court, they have deposited the amount also, my lord, before the collector.
SLP was filed before Supreme
Yes, my
Court.
lord.
Against which order?
Against, my lord, in the current writ petitions, my lord, they sought interim order, my lord, for staying of the, my lord, land acquisition notification and the award, my lord. And the honorable court has rejected the interim prayer, my lord. Against that interim prayer, my lord, they went to SLP, my lord. But SLP, my lord, they have not interfered, my lord. Instead, my lord, they have directed to deposit the, my lord, compensation amount before the collector, my lord. And they are in possession of our land also, my lord.
No, my lord. Exactly.
Ladyship, may I
Exactly,
say
my lord.
something?
That
Your
we
ladyship,
went to
may
the
I say
Supreme
something
Court
before?
on the ground, by way of SLP, my lord, on the ground that there was some strictures order passed by the honorable single bench, wherein if it is not complied with, my lord, the personal appearance was called for. Then, so as to escape the, my lord, the death order, my lord, expounds the death order. Yes, my lord. Therefore, on the very beginning,
Looked into.
yes, my lord. On the very beginning, therefore, my lord, it was my submissions that detailed argument, my lord, detailed submission is required, my lord.
We'll fix it on another date.
My lord.
Have all your materials ready. We'll give it we'll fix a date so that the next division bench can address this matter straight away,
My lord.
having ample time.
And for
Is it-
convenience of the bench, you prepare a chart because so many petition have
I'll do that.
you compare the
Okay.
Sure.
arguments that have been
I'll do
taken. The principles of adjudicate also you are arguing. So it will be convenient for this court
Correct.
to understand because too many facts are there. You prepare a
Sure.
short note.
I'll do that. Sure.
So, when should we list it?
My lord, any
Let's
convenient date
take it
subject
on
to.
Monday, which will be the first Monday of the next bench, which will be on the sixth. Come prepare without asking for adjournments, so that at least the next bench will have ample time to pursue
Your-
with all the available.
Your lordship are fixing
It's
the
another
matter.
date. Again, it will be the last week for this bench.
My lord.
It will be difficult, I think.
Your lordship is
But
fixing the
Mr.
matter on 6th.
Kato, is it learned council, learned
M.
DSGI, learned council for the Union of Appellants. Along with Mr. Yes,
One is Saikya, R Saikya.
our second.
Mr. Saikya, you are for?
I'm for respondent
Respondent?
number, my lord, 6, 7, and 8, my lord.
For the state respondents.
No, private landowners, my
Private,
lord.
okay, for
Six,
the
seven.
private landowners, 6, 7, 8, and
And who was appearing through VC?
and, okay,
The
Mr.
PC.
So and so, learned government advocate for the state respondents.
Rectu Raj is appearing 4 to 6.
Mr. R.
Raj,
Rectu Raj.
Ritu Raj, for respondents number
4 to
4 and
6.
6. Having heard the submissions made by the learned councils, this court find it fit that this matter may be listed on 6.
Well.
5 so and so. Oh, hearing.
Deeply.
I'll be dealing. I need some time for reconstruction of this file. 2 weeks time may be given, my lord.
You are for the petitioner.
I'm 40. For item number 44, I'm for the respondent. And 45, I'm for the petitioner. And 46
Yes,
also, I'm for the petitioner. And 47, I am for the respondent, my lord.
okay.
Yes.
Mr.
Udeka, my lord.
Deka, learned council submits that he has been recently appointed to represent the parties, some of the parties in the instant writ petitions, and that he may be given some time to prepare for the matter. In view of the above, list after
2 weeks, my lord.
2 weeks.
Highly ordered.
Your Lordship, I beg to mention item number 3. We are for the petitioner hearing, Your Lordship. I pray that the matter may be listed after 2 weeks, Your Lordship. In the meantime, we'll file our affidavit in reply.
In reply,
Yes, Your Lordship.
is your name here in the cause list?
Yes, Your Lordship. D. Tamuk.
Okay. Ms. Tam, learned counsel for the petitioner, has prayed for time for filing of the affidavit in reply. In view of the above, list after
2 weeks, Your Lordship.
2 weeks.
Obliged.
My lordship, I beg to mention item number 9 and 10, my lord. In this matter, we have to file an affidavit. Give us time for filing affidavit. In this matter, we have to file affidavit, man.
Counter,
Yes, my lord.
you're for the
I'm for the
respondent.
respondent now. I'm mentioning on behalf of MCATO, DSGA.
Okay. Mention is made on behalf of Mr. M. Kato, learned DSGI for praying for time for filing of the
4 week, madam.
affidavit. In view of the above, list after 4 weeks.
Highly obliged.
Milords, in these matters, Milords, I am appearing for petitioner, Milords. Milords may kindly continue. The interim order is there in item number 10, Milords. Milords may kindly continue it.
Okay, Miss T.
I am Puneet Agarwal.
Okay, Mr. P. Agarwal, learned counsel, appearing for the petitioner is present and praying that interim order may continue. Accordingly, okay, then list after 4 weeks. In the meantime, interim order passed earlier shall continue till the next date. No?
Grateful.
Yes,
Milords may make it absolute, Milords, the interim order. All
till
right,
the next date.
grateful.
My lord, make back to mention item number 23, my lord. My lord,
23.
yes, my lord. My lord, I'm here for the my lord, private respondent. And my lord, I need some more time to file affidavit now.
Mr.
T. Lampung.
T. Lambung, appearing on behalf of the private respondents, have prayed for further time for filing of the counter affidavit.
My lord, 3 weeks time may be granted.
In view of the above, list after 3 weeks.
My lordship, there is an interim order.
Mr. So-and-so, learned counsel for the petitioner is present, same and has prayed for continuation of the interim order. In view of the above, the list after so-and-so, 4 weeks. 4 weeks you prayed, isn't it? In the meantime, interim order. Yes.
Highly available.
Your Ladyship, I beg to mention item number 5. I'm for the petitioner.
Yes, he is so.
Sonam Somu.
Yes, Miss, so what are you praying for?
We have to file the rejoinder here, so we
Okay,
seek
Miss
3 weeks time.
So learned counsel for the petitioner has prayed for further time for filing of their rejoinder affidavit. Accordingly, list after
3 weeks.
3 weeks.
Much.
Lordship, I beg to mention item number 21.
21. Yes.
Lordship, I need some time. I'm on behalf of Titaba.
Miss so-and-so, your good name
N Honde.
appears on behalf of the learned counsel for the petitioner, Mr. P. Taba, and has prayed for further time for filing of their rejoinder affidavit.
Lordship, I need some time to file rejoinder affidavit.
Accordingly, list after. how
After
many
2 weeks.
2 weeks. Yes, granted.
My lords, I beg to mention item number 6,
6.
15, 16, 19, 22, and 48.
6, then
15,
15,
16,
16,
19,
19.
22,
You're appearing for whom?
on behalf of Pritam Tapos,
Yes, 22 and
48. Well, the council is out of station.
48. Okay. Mention is made on behalf of Mr.
Pritam Tapos.
P. Tapu for adjournment of the matter since the
List.
learned counsel is said to be out of station.
After
Accordingly,
2 weeks.
list after
2 weeks.
2 weeks.
My lordship, in item number
Take it in
15,
view of
lordship,
the
there is,
above, okay? Yes,
item number 15, lordship, there is an interim order, lordship.
in item number 50,
15, lordship, 15.
15, meanwhile, interim order passed earlier shall continue till the next return.
All right.
Lordship, I beg to mention item number 42.
Yes, you're appearing.
For respondent number 6 to 11.
Counter? No, here adjournment. Yes.
Yes. Matter may be-
Mr. You're appearing for
respondent number 6 to 11.
Mr. So-and-so, learned counsel for respondent number 6 to 11 has prayed for adjournment. With the consent of the petitioners?
Yes.
With the consent of the petitioners. In view of the above, list after
2 weeks.
2 weeks.
And lordship, item number 1.
Yes,
Here I'm appearing for respondent number 7 on behalf of El Perme, Standing Council Power Department.
okay, Mr. So-and-so, appearing on behalf of learned counsel for respondent number 7, Mr. El Palme, has prayed for adjournment. In view of the above, list after 2 weeks.
Yes. Highly obliged.
When I'm appearing on behalf of Standing Council, Mr. Tabatagum. I'd like to mention item number 24 to
Okay,
24,
analogous matters 24 to
39, Your Honor.
39.
39.
You're appearing for?
Standing Council Tabatagum.
Okay,
And Your Honor, 41 also. We are
Mr.
taking consent from,
So-and-so,
we are taking consent from the other parties, so Your Honor, this matter will be listed after 3 weeks.
learned counsel for the respondents has prayed for adjournment with the consent of the petitioners. In view of the above, list after
3 weeks.
3 weeks.
Yes.
Yes,
May Your Lordship, I beg to mention item number 43.
Pleasure.
We may be allowed to file our rejoinder. Your Lordship.
now this is listed for hearing. If
Yes,
it's
Your-
listed for hearing, most probably Pleadings are complete. 43.
We need to file our rejoinder, Your Lordship. That's why we need some more time.
Then how come, let's see, item number 43, what was the last order? Pleadings are not complete, it appears.
At that point of time, it was complete, Lordship. They were there when the matter was fixed for hearing.
Let's see how was the order made. Item number 43.
But on the last occasion, this case was extensively argued. But then in the meantime, it emerged that some clarifications because the government is relying on certain notifications, and those notifications are to be produced. And then against that, since they are claiming that only me and another person is being issued the notice, whereas in that area there are more than 100 buildings, high-rise buildings. So that facts has to be brought to the before the honorable court. So I may be
You are the
given.
counsel for the petitioner.
Yes, I am for the petitioner.
See,
So
on
that
perusal
I'm
of
preparing
the orders of this court, it was also dismissed at one stage for non-prosecution of the matter.
Yes, Lordship. Yes.
So that pertaining to that claim, I am preparing my response. I may be just given one opportunity.
Anyway, is Mr. H.K. Jaman, is it? For the petitioner?
T.
Patil. Learned counsel for the petitioner. See, sometimes their names are not reflected. This is true. Okay, T. Patil, Mr. T. Patil, learned counsel for the petitioner, submits that though this matter was listed for hearing, he may be allowed to file a rejoinder affidavit to clarify certain points in the counter affidavit filed by the respondents. In view of the above submission, this matter is released from hearing list and to be listed under admission. Meanwhile, the learned counsel for the petitioner is to file the rejoinder affidavit. Positively.
Positively, Lordship, unless that if they don't file, matter may be taken up
Positively
for
by the
admission
next
hearing.
court date. List, when, how much time will you take?
2 weeks.
List after 2 weeks.
Yes, Lordship.
Yes.
And Your Lordship, I would like to mention item numbers 11, 12, and 3. 11, 12, and 3. In this matter, Your Lordship, the government is considering the promotion for all the interested parties, Your Lordship. That's why all the councils have agreed to adjourn the matter for today.
You are for the?
Petitioner in item number 11.
Okay, anyways, Mr. You're appearing for whom? Is your name there in the cause list?
No.
Then you're appearing for?
Yes, Saxena.
Okay, Mr. So-and-so appearing on behalf of Mr. Kamal Saxena. Is it learned counsel for the petitioner? This is in?
Item 11.
11.
Yes,
Okay.
sir.
Has prayed for adjournment with the consent of the respondents. Then in 12?
Yes, in 12, we are respondent number 6.
Then-
Petitioner in item number 12, Counsel T. Garam, he has also given his consent. He has also.
Okay,
See.
then in 12, it will be with the consent of the learned counsels for the petitioner, the counsel for respondent number 12. No, respondents have prayed for adjournment. Accordingly, just after 2 weeks, is it?
4 weeks.
After 4 weeks, all
Yes.
the matters, 4 weeks.
Yeah, 11,
What
12,
about
and 13.
Same, you are for the petitioner here, 13?
No, we are not a party, but all these matters are connected. They are from the same,
Okay,
they arise
different
from the same
matters.
cause of action, yeah.
After 4 weeks. Okay, no.
Consents within themselves, they have taken the consent. Very good.
So I think it will be easy if we just pass, we just mention that with the consent of the parties as prayed for, list after 4 weeks,
4 weeks.
instead of mentioning names. Okay. Yes.
And finally, item number 17, Your Lordship. This matter is pending before the apex court, Your Lordship. We are awaiting the adjudication of this matter.
Mr. So-and-so appearing on behalf of Mr. K. Saxena. Is it?
PK Tiwari in this matter.
Okay, here PK Tiwari,
Yes, Your Lordship.
learned counsel for the,
Petition.
his name is
Respondent number 2.
learned counsel for respondent
NHPC.
number 2.
Yes.
Submits that this matter is pending before the apex court and.
I mean, matters which are directly linked with this.
Okay, matters which are similar to the instant writ petition are pending before the before the apex court, and the outcome of the apex court may be awaited. In view of the above, this after 4 weeks.
4 weeks.
Hmm.
Much obliged.
May I, Lordship, Lordship, I beg to mention item number 20. Here, the respondents have not yet filed their affidavit, Your Honor. The matter may be adjourned. And service upon respondent number 5 is still awaited. Matter may be listed after.
So you are for the petitioner.
I'm for the petitioner.
Have you filed your rejoinder? Are you filing? No.
No, they have not filed, Your Honor. Opposite party have not yet filed their affidavit.
Okay, no counter affidavit.
Yes, Lordship.
Mr. So-and-so, learned counsel for the petitioner is present and submits that the counter affidavit is still not filed by the respondents. And that the service report upon respondent number 5 is still awaited.
And Lordship, entry may be continued. There is an
View of
entry.
the above, matter is to be listed after 3 weeks. In the meantime, interim order passed earlier shall continue till the next date.
Obliged, Lordship.
Item number 2.
Some more time to
You see, now in this case, the office note dated 1/2/2023 indicates that affidavit certifying that affidavit of dusty service to respondent number 5 is not furnished.
No, they have appeared, Madam.
Yes,
Private respondent
okay,
five.
you are for respondent number 5.
They have filed their wakalatam also.
So now respondent number 5. Counter. Okay, Mr. So-and-so, your good name, please. Mr. The learned counsel for respondent number 5 has prayed for further time for filing of his counter affidavit. In view of the above, okay, then Mr. So-and-so appears on behalf of the petitioner along with Ms. So-and-so, learned government advocate. In view of the above, this after 2 weeks.
Interim order may be continued.
Meanwhile, interim order passed earlier shall continue till the next date of listing.
Obliged.
Item number 4.
Yes.
Lordship may kindly peruse order dated 04/01/2024, Lordship. In this very order, Lordship, the last occasion it was categorically made clear in the last paragraph, Lordship. Last paragraph of the order, Lordship. I'm reading, Lordship. It is made clear that if the respondents do not file their counter affidavits as permitted, this court may proceed for hearing of the matter on the basis of the pleadings available on record. After this order also, last opportunity was given to them for filing their counter affidavits, Lordship.
So what happened?
Till today, I think they have not come up with their instructions.
Anything to say in this matter? Is it? Who has to file the counter affidavit? DSGI and government advocate, both of you?
Yes.
Then?
Our reply is not forthcoming till now. We have,
Which department? Maybe you don't have anything to say. What is the petition about? For payment?
Lordship.
Compensation?
Compensation, Lordship. In regards to Lordship.
What has been made? Is it
Award
an
is
award?
made, Lordship. Page number, Lordship, page 71, Lordship, may kindly see, Lordship.
here the main party is the union. They have to deposit money to the state government. We have not received.
Page 71, Lordship. It's the type
Yes.
copy, Lordship. It's clear from these documents that already the award has been prepared. Beneficiary list is
Submission of estimate as approved by government. So, yes.
already
Could you
submitted,
consider-
Lordship, to the BRO,
Yes,
Lordship.
yeah.
My lord, some more time may be granted, my lord. I'll take instructions from the respondent department. It's because my lord, so far I haven't received my lord, any instruction from the.
You have to take steps to contact them.
My lordship, it's been almost 1 year, Lordship. So while in the last order, Lordship, Lordship has categorically given this order, Lordship. Seeing
That was
into
on January 2024, isn't it? Almost 1 year, you say.
I'm for the respondent number 125, madam. Lordship, case is also very simple, Lordship. They acquired the lane, everything process was completed, Lordship. The estimate was submitted to them, Lordship. Their duty was to just submit the amount, Lordship. They are not doing it, Lordship. They are running away from their responsibility, Lordship. Page 91, Lordship, will make clear how they are trying to run away from their responsibility, Lordship. Responsibilities, Lordship. In page 91, annexure 22, Lordship.
Yes.
Lordship, I'll just directly take to your Lordship to page 4, Lordship. Lord, sorry, paragraph 4, Lord, sorry. The matter is delayed due to non-finalization of LA from kilometer so and so by Deputy Commissioner Lohit District. My lane is in Dibang Valley, Lordship, Lower Dibang Valley, not in Lohit District, Lordship. Lohit District, as the LA payment will be approved by mode for the total strength from kilometer so and so as single case. The road has been handed over to PWD Arunachal Pradesh as on date, but the payment can still be made against the sanctioned job on receipt of revised approval from mode and they are not to pay the compensation from the job, Lordship. Next paragraph, Lordship. Paragraph 5, Lordship. Alternatively, state PWD may be approached to pay the land compensations as the road is now held with them and the liability to pay compensation for road and road lane rest with them after taking over the responsibility for maintenance and improvement of this road sector, Lordship. Now they are trying to hurl their responsibilities to the government, Lordship. In this regard, Lordship, page 93. Clearly, the Deputy Commissioner of the concerned area has categorically clearly given his reply to this very letter, Lordship, communication letter, Lordship. Paragraph serial number 1 and 2, Lordship. The compensation of Lower Dibang Valley District and Lohit District may not be linked with each other. Deputy Commissioner are land acquisition authority for their respective jurisdiction and the land acquisition matter of one district cannot be made dependent on the issue of another district's, Lordship. But I was contending, Lordship. My lane is in another district. Now he is taking the resort of another districts where certain disputes are there, Lordship. In our case, no such disputes, Lordship.
So-
Serial number 2 also, Lordship.
So
Yes.
you are for which district?
Lordship, I am in Lower Dibang Valley, Lordship.
Lower Dibang.
Lordship, rowing, Lordship.
my lane is in another district, not in Lloyd district, Lordship. Now this deputy commissioner has categorically made clear, Lordship.
So you are Dibang Valley District.
Lordship, I'm in Lower Dibang Valley district.
Now,
My
this
lane is
by
in
the
Lower.
Deputy Commissioner.
This is
It's a state, isn't it? It's represented by the state.
Lordship.
Or Deputy Commissioner, who is this? You're not made
State
that-
will represent, Lordship.
So you have not filed your affidavit also?
Lordship, they from their end, I don't think they have any grievances in regards to this case, Lordship. They are
Is it?
categorically making it clear.
Can we see that we submitted the
Estimate.
So you're not filing any counter? You don't have to file a counter in this matter, isn't it?
till now we have not received, so I can't say, I don't have to file. If I receive in between, I will file also, but then
If you receive what?
instruction.
It's been almost 1 year, Lordship. They are saying the same thing, Lordship. Instruction upon instruction. Lordship, I don't know how far they gonna take time, Lordship, to get the instruction,
We'll give
Lordship.
you another chance because this court's order dated 9/2/2024 appears to have.
Lordship, so why my prayer before your Lordship is
Yes.
today is in this case, Lordship will see that simple direction is required, Lordship, to the BRO to disperse within certain period of time, Lordship. Then only they will act upon, Lordship. Otherwise, Lordship,
We'll give them one more chance, no further adjournments.
Well,
By reflecting this court's order dated 04/01/2024, which was not reflected by this court in its order dated 09/02/2024.
plus after subsequent hearing of that order, Lordship, last opportunity was accorded to them, Lordship. As they have pleaded,
That
Lordship.
is not reflected here, isn't it?
Lordship.
So simply closing their chance now, when in the previous court order, nothing was recorded of that nature. I don't think that would be appropriate. But today's court order will reflect that so that no other adjournments can be made.
All right.
Right, Mr. N. Saro.
J. Genie, Lordship.
Pardon?
For the
J.
petitioners, Lordship. J. Genie.
Genie, learned counsel for the petitioner, along with Mr. M. Kato, learned DSGI, and Miss
1 to 5 minutes.
learned for respondents number 1 to 5, and Miss G. So and so learned government advocate, is it?
7 and 8 only, Lordship. I am
For respondents number 7 and 8. And Mr. So and so, counsel for respondent number 6. The learned counsels for the respondents have prayed for further time for filing of the counter affidavit. While Mr. So and so, learned counsel for the petitioner, brings to the notice of this court the order of this court dated 04/01/2024, wherein this court had observed that the matter be listed on 9/02/2024. And if the respondents do not file their counter affidavit as permitted, this court may proceed for hearing of the matter on the basis of the pleadings available on record. Full stop. However, it is seen that on 09/02/2024, time was granted to the respondents to file their counter affidavit. It is seen that the respondents till date have not filed their counter affidavit. And in view of the above, this court, in the interest of justice, file their affidavit, while the learned counsels for the respondents have prayed for further time, submitting that they have yet to receive instructions from the respondents. In view of their submissions made, this court find it fit to give a final chance to the respondents to file their counter affidavit. Failing which the court shall proceed with the matter on the basis of the pleadings available on record. It is to be noted that no further adjournments will be granted for filing of the counter affidavit. Accordingly, list
Lordship,
Yes.
can we have a fixed date, Lordship?
On-
Can it be on 13 May, Lordship? It's,
Madam,
we are giving them 2 weeks time here.
After 4 weeks, madam.
4 weeks would be,
This is the last opportunity is giving, madam. So it-
otherwise, can it be on 20 of May, Lordship? They are having 4 weeks time.
list on
30.
20
20 of May.
May.
20. All right. All right.
They play plus.
Item number 7.
Yes, Miss so and so, non-government advocate appears on behalf of the respondents. While none appear for the petitioners. In view of the above, list after 3 weeks.
Item number 8.
We have played my lord, Lordship. This matter relates to, we have filed for the revocation of suspension order. Well, in this, well, in this matter, respondent number 1, 2, 2, 3, 4, I think they have filed the affidavit, counter affidavit. But an important party is 5, 6. They are yet to file affidavit, your lordship. In fact, in this writ petition, what we are challenging is that suspension was done to the member of the Arunachal Pradesh State Commission for Public Service Commission member.
Yes.
he-
So it's a central.
Yes.
Hmm.
So, in fact, the suspension could be done under section Article 317 sub clause 2 after the reference sent to the Supreme Court and after the report, then only the suspension can be passed by the concerned state. But in this case, without complying the Article 317
with the
sub clause 2, that is the issue here. Your
Okay,
Lordship.
you were suspended.
Yes.
So who has to, now then the respondents number 5 and 6, they are representing the
Presenting, in fact, the central government is a
central
ministry.
government. So,
Yes.
so are you going to file your counter?
Secretary
Anything to
Minister.
say in this matter, or you don't have?
Of the respondent number 5 and 6 may not be recurrent because madam, every action has been taken by the state, taken by the state government.
Yes, so the respondents.
Consultation part,
But the-
madam, correctly explained by the state respondent. So because madam, admittedly, madam, if it is placed before the madam, the union of India, madam, the union of Secretary.
My lord,
One expect, that yes, that address has to be done, madam, that correspondence has to be done. Madam, ultimately, the entire thing has been done by the state government.
So
My lord,
the
this,
union
writ
says they
petition
don't have
is-
to say anything in this matter.
Madam,
No counter. You don't have to file any counter
case, if so,
because the WPC is against the action of the state
madam.
respondents.
yes.
No,
If you don't want to file, it's in your favor then.
No, in fact, the whole correspondence which is done by the Ministry of Personal Affairs to the Supreme Court and to the President of India.
You
As
get
per,
instructions, have you received?
Madam,
So let him receive instructions whether they want to file or
Otherwise,
not,
my lord,
because there is correspondence
yes,
where the union was also involved, is it?
yes.
my lord, otherwise the whole writ petition is misconceived.
No, this is not a-
That will say.
Yes, my lord, it is by his own interpretation of Article 317 itself, it's very clear. Once the reference is made to the Supreme Court
No,
by
that-
the president. In that event, pending report from the Supreme Court, the governor can suspend.
So you're saying the governor has the power, he says he doesn't.
Governor can
Why-
Governor, his case is that before the report is, only after the report is given, then only it can be, he can be suspended. But the case is, it is very clear that
According to
before
you,
the,
yes, he
before
Before
the
the-
report,
Yes, that's what.
after the reference is
So
made.
when
and
it is
before the-
illegal, it's illegal. That's what we are challenging, the impugned order.
So-
That's
so-
what we are challenging.
let the Union of India get instructions in this matter, whether you'll be required, because the petitioner says that some documents have been issued by you where you have to address those documents. Okay. Mr.
Asmo.
Asmo, learned counsel for the petitioner is present, along with Mr.
N. Ratan.
N. Ratan, learned additional
Additional
AG. And Mr. M. Kato, learned DSGI, appearing for respondents number 5 and 6. It is seen that respondents number 5 and 6 have yet to file their counter affidavit, wherein the learned DSGI submits that he has to get instructions in this matter. In view of the above, list after, when will you be ready? 2 weeks, 3 weeks?
4 weeks then. Your lordship may
It will
pick
be
the
after
date.
4 weeks.
Date may be
List
fixed.
after 4 weeks on, give me a date, 4 weeks,
20
25.
of like.
Yes. Anything else? What, hearing? Oh. Now there are 3 matters. Let's call first and see if we can dispose of. If it's for adjournment, if it's hearing, then we'll.
Item number 40.
Few matters, instead of sitting again at 2, let's see if we can dispose of. 14, rejoinder affidavit has to be filed.
Yes.
Oh.
Respondent number 7, 8 and 9.
Ah. None appeared for the petitioners, while the learned counsel for the respondents are present. And have you filed your rejoinder?
No, no, sir.
And prayed for, maybe we'll mention their name. Why?
Here,
Mr.
also, I will not be filing this affidavit, Lord, sir. It is not required from my side.
Okay,
I'm
none appeared
for
the
respondent number
petitioner,
4.
while Mr. So-and-so learned government advocate.
I'm assistant counsel and management department.
Okay, standing counsel for so-and-so submits that they are not required to file their counter affidavit in this matter, while Mr. So-and-so appearing on behalf of Mr. Winter Pichari, learned counsel for respondents number
7, 8 and 9.
7 and 9 has prayed for time for filing of the counter affidavit. In view of the above, list after 3 weeks.
Item number 13.
None appeared for the parties on court. List after 3 weeks.
I'm appearing to respondent number 1, Lord, sir,
Okay.
in this case.
Item number 18, Mr. So-and-so appears on behalf of respondent number 1, while none appeared for the petitioner. In view of the above, list after 3 weeks.
Item number 14.
Yes.
May I please, your
Yes,
lordship?
supplementary, yeah.
Lordship, I'm very ashamed to say this is due to my fault that some things which ought to have been in the petition were missing, Lordship. So that is why I have filed this petition, application for amendment, Lordship. The things that have been missing have been indicated in para 3 and para 6.
So, this is the first time it's coming up, so will issue notice?
Lordship, if it can be allowed, because we are in a
Any
Hurry, Lord.
objection to be made in this matter?
No objection. Amendment.
No, okay. Heard Miss
N. Duncan.
N. Duncan, learned counsel for the applicant, who has filed the instant application under Order 6, Rule 17 of the Code of Civil Procedure 1908 for amendment of the writ petition. The learned counsel submits that
It's in para 6, Lordship, page 50.
okay, the amendment. which
The
is
proposed
re-
amendment.
The proposed amendment which is required to be made has been highlighted in para 6 of the IA. And submits that the amendment will not affect the main writ petition or the prayer portion. is it?
Yes.
In the writ petition. Mr. So-and-so, learned counsel for the respondent is present. Copy of the IA is duly furnished to him, and therefore formal notice is not required. The learned counsel for the respondent submits that they will have no objection to the proposed amendment made by the applicant. In view of the above submissions, the application made for the amendment as highlighted in para 6 of
Yes.
the application is duly allowed, and additional affidavit may be allowed to be filed, making the said amendments in the main writ petition. Number, what is the writ petition? 171 within brackets AP 2024.
Obliged, much obliged.
Accordingly, ISO and so stands allowed and disposed.